Oh, instead of co-host, you're right. Okay. This meeting is being, okay, hold on. It's not a good morning.
Good morning.
A moment. Oh, instead of co-host, you're right. Okay. Okay, we're good to go.
Good morning, everyone. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. Today we have a confirmation hearing. Before we begin, we will begin with committee introductions, beginning with Senator Farron. Senator Farron, would you like to introduce yourself, sir? I think, let's see, ask to unmute. I'm going to do that and see. I'm going to ask everyone to unmute right now.
Apologies, I was technology challenged and having an issue.
You may introduce yourself, sir.
Yes, hello, I'm Brad Farron, representing Senate District 3, and apologies for the technical difficulties this morning, but thank you for being here.
Senator Miramont.
Good morning, Dave Miramont, representing Senate District 12, which is Knox County, except for Washington.
Representative Supika.
Good morning, I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Wood.
Good morning, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Riley.
I'm Representative Riley. I represent House District 34, which includes part of Westbrook.
Representative McCright.
Good morning. I'm Jay McCright, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Representative Kinney.
Good morning. I'm Mary Ann Kinney. I represent House District 99.
And we also have with us our committee clerk, Darlene Semino, who will call the roll when we get to that point. Representative McCright, would you like to do the nomination for us today since Representative Piazzo is not with us? You ready to do that?
Yes, thank you. Can you hear me okay?
I can hear you just fine.
I move that the joint standing.
Not yet.
Okay.
I just wanted to make sure you'd be ready to do it. I've got to go through the script. Thank you. So with that, this is a public hearing of the Joint Standing Committee on Veterans and Legal Affairs for the purpose of considering the nomination by the governor of Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices. Under the rules of the legislature, the committee is required to hold this hearing, and it is recommended confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. The meeting will be recorded and available to view on the committee's YouTube channel soon after the meeting is concluded. Pursuant to Title III, Section 157 of the main statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative McCright for the purpose of making such a motion.
Thank you, Mr. Chair. My excuse is I was distracted by the beautiful baby. I move that the Joint Standing Committee on Veterans and Legal Affairs recommend confirmation of Ms. Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices.
Thank you, Representative. A copy of the statutory requirements for this commission are available for us to review. The chair now recognizes Joseph Bushi for the purpose of making a statement concerning this nomination. Good morning and welcome, sir.
Thank you. Good morning, Senator Hickman, distinguished members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Joe Bushi, and I am the Deputy Director of Boards and Commissions for Governor Mills. I'm here today on behalf of the governor to speak in support of the nomination of Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices. The commission consists of 5 members, One member recommended by the appointed leader from each political party in the Senate and the House, and a fifth member jointly recommended by legislative leaders. Stacy Newman of Scarborough is nominated to fill the seat, which requires a recommendation by House Democratic leadership. She's a magna cum laude graduate of James Madison University with a degree in English and Media Arts and Design, and earned her JD from Cornell Law School. Since leaving law school, Ms. Newman has clerked for 2 justices in the state of Vermont and spent 2 years in the public defender's office in Chittenden County, Vermont. In 2009, Ms. Newman joined the U.S. Attorney for Maine's office as an assistant U.S. attorney, where she spent 4 years before entering private practice at Murray, Plum & Murray in Portland. She currently chairs the firm's employment litigation group and its criminal defense group, and serves on the firm's management committee. Outside of her role at Murray, Plum & Murray, she has served on numerous boards and committees dedicated to furthering the practice of law, including the U.S. District Court Criminal Law Committee for the District of Maine, the Board of Governors of the Maine State Bar Association, and the Board of Directors for the Maine Association of Criminal Defense Lawyers. She's also been an invited lecturer or presenter at multiple law schools and conferences. Stacy Newman's extensive legal knowledge and commitment to public service make her eminently qualified for appointment to the Commission on Governmental Ethics and Election Practices. And on behalf of Governor Mills, I would urge you to support her nomination. I'd be happy to take any questions you may have.
Thank you, Mr. Bushy. The chair would ask if any member of the committee has any questions for Mr. Bushy at this time. Seeing none. You're off the hook, sir. The chair now recognizes Ms. Stacy D. Newman, Esquire, for the purpose of making a statement concerning this nomination. Good morning and welcome.
Good morning. Thank you. Thank you, Senator Hickman. I know Representative Piazza isn't here. Thank you, members of the Standing Committee on Veterans Affairs. My name is Stacy Newman. I live in Scarborough. My little daughter was on the screen a moment ago, but my dad has taken over so that you can hear me speak. I'm here today to discuss my nomination to the Commission on Government Ethics and Election Practices. First, I'd like to thank the governor for nominating me to this position and Mr. Bushy from the governor's office for presenting my nomination this morning. Speaker Fecto's office approached me about serving on the commission, and I was immediately interested. As a lawyer, I believe we have a special duty to our democracy, which is why I'm interested in serving in this capacity. It would be an honor to use my skill set and my interests in service of our state and citizens and the election processes in this way. As a lawyer, I am dedicated to, trained for, and experienced in the process of law and the fair and transparent administration of the law. In my legal career, I've worked in many capacities, including both as a defense attorney, a prosecutor on the criminal side, plaintiff's counsel and defendant's counsel on the civil side, and a neutral investigator ferreting out facts and making reasoned and unbiased decisions. We lawyers are bound by strict rules of ethics, as well as professional norms that guide us, and appropriately so, given the nature of our work. As the mission statement for the commission states, commission members are appointed for their probity, judgment, and objectivity. My legal experience can give you and the legislature confidence that I have such qualities. My work on both sides of the aisle in various cases demonstrates my ability to be objective and fair. My decades of experience counseling clients in numerous situations, as well as rendering decisions as a neutral investigator, is demonstrative of my objectivity. And my reputation and high ethical standards within my profession and outside of it signal my probity and integrity. Navigating procedures, rules, and regulations are my livelihood, and I'm looking forward to using my skill set in this context. Finally, I'm a member and have been a member of many different boards, large and small. I'm a fair, collaborative board member and work well with my fellow commissioners. In addition to my legal experience, I also bring my life experience. As a working mother of now 4 children, you've seen the newest one. This particularly includes the ability to multitask, a thick skin, a sense of perspective, and I like to think a sense of humor, all of which can come in handy in many situations. I'd be glad to take any questions you may have, and I hope to obtain your support for confirmation to the commission. Thank you.
Thank you, Ms. Newman, and congratulations on your nomination. Are there any members of the committee who have any questions of the nominee? Seeing none, I guess you presented yourself so well. The chair will now take comments from persons attending the hearing who wish to speak for or against the nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to written comment. Ms. Semino, did we have anyone sign up to testify in person on behalf of this nomination?
There's two people sitting in the attendee room. I'm assuming that they're signed up to testify.
If you are signed up to testify, please raise your hand. I see Mr. Peter Murray has done that. I will invite him into the room. Those who wish to speak in person, register with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will promote it to panelists, which I've done. When it is your turn to speak, please state your name, place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members, you will be returned to attendee status and the next person will be called. With that, the chair recognizes Mr. Peter Murray to make a comment regarding this nominee. Good morning and welcome.
Good morning, Senator Hickman. Good morning, members of the committee. It's a pleasure and an honor for me to appear before you in support of the nomination of Stacy Newman for the commission. I've known Stacy Newman for almost 10 years and the capacity of a fellow lawyer, a member of the bar, and a fellow law firm member. She's also become a good friend. I think there are three reasons why I can enthusiastically support a candidacy. First of all, Stacy has wonderful experience for this kind of a position. She has been on both sides of the criminal law, both as a prosecutor and as a representative of persons accused of crime. And that gives her a wonderful wide perspective on the kinds of problems that the commission is likely to be faced with. Second, I've known Stacy as a person of absolute integrity. She is hews to a very high standard of ethical conduct, and she comes out of a background of high ethical practice for the government and I hope within our law firm. She is kind of looked upon as a resource when people want to talk about difficult ethical issues. Third, and I think it's probably obvious to you just meeting Stacy, she has a wonderful understanding of her fellow human beings. She is empathetic, she's sympathetic, she listens, she's willing to accept other viewpoints, she's supportive of others, she works cooperatively with others in a group. She's the kind of person that's a pleasure to be around and a pleasure to associate with. So for these reasons, I believe that Stacy Newman would be a wonderful member of the Commission on Governmental Ethics and Election Practices, that she would bring sound judgment to the deliberations of that group, that she'd bring humanity to its activities, and that she would bring a great sense of collegiality to her fellow commission members. So I urge the commission to approve her candidacy. Thank you very much.
Thank you, Mr. Murray. Are there any questions for Mr. Murray from the committee? Seeing none, we appreciate you being here today.
Thank you.
The chair will now recognize Mr. Peter Plum to provide testimony in support of the nominee. Whenever you are ready to begin, sir, if you can hear me, you may turn on your mic and or your camera. Good morning.
Good morning, Mr. Chairman, and thank you, members of the committee, for an opportunity to testify in favor of my partners in law and a good friend, Stacy Newman. I am Peter Plum, and Peter Murray and I, of course, are birds of a feather in this, and I echo his sentiments. But I would say a couple of additional things. I've known Stacy as a lawyer and a friend now, and as a partner in the firm for about 10 years. And I would say that she's one of the smartest people I've met. She's also one of the most organized people I've ever met. She can multitask, as you've seen with the recent addition to her family, extremely well. As a criminal defense lawyer, she has to have, I mean, all lawyers have to have a heightened sense of ethics and the code of ethics that we live by. But as a criminal lawyer, you have to have an especially heightened sense of ethics and what is permissible and what is not, and what is appropriate and what is not. And Stacey certainly has that. She's got a wonderful, wonderful intuitive sense about what's right and what's wrong in any given circumstances. She is a member of our management committee, which is a tough assignment. It takes up a fair bit of time. And of course, the most sensitive issues that a law firm can have come before the management committee. And she plays a very, very important role in that. And her opinion is always sought after, not just on the management committee, but firm-wide. So we've already had testimony about the statutory test of persons of recognized judgment, probity, and objectivity. And I think Stacey fulfills all of those easily and handily and with great style and empathy. I think she'd make a great addition to any governmental commission, but she certainly is an appropriate person and would do a wonderful job in the position for which she's been nominated. Thank you for the opportunity to address you.
Thank you, Mr. Plum, for being here. Are there any questions from the committee? Seeing none, we appreciate your time, and we will hope that all of the work that she does for the commission will not interfere with the great work that she does as a partner in your firm. Thank you for being here.
We appreciate that too.
Are there any other people present who wish to testify on this nominee? Seeing none. All public comments having been taken, the committee will now proceed as follows. Review any additional written comments. Excuse me. Senator Miramont.
Thank you, Mr. Chair, and welcome, Ms. Newman. The question arose by the supporting testimony and your own and your resume. You're a busy person, and this is not one of those committees that meets once every year or maybe a couple times because nothing much happens. This one gets pretty busy, the commission, and can go all day. It's not that anyone wouldn't miss a meeting once in a while, but have they talked to you about the commitment that this actual board requires? And do you think that you'll be able to be there as much as the other commissioners? Because they do make some important decisions in the heat of elections. That's the question that arose during the testimony. Thank you.
Thank you, Senator, for that question. I think that is really important. And yes, we spoke a lot when I was approached about being on this commission about the time commitments, and I thought a lot about it. As you probably tell from my resume, I kind of thrive on activity and busyness, and I certainly would not have committed to being before you if I knew I wouldn't be able to commit fully to being on the commission. If that answers your question. If not, please, I'm glad to expand.
It does. Thank you very much.
Thank you.
Thank you for that clarity, Senator Miramont. Thank you for that clarity, Ms. Newman. So all public comments having been taken, the committee will now proceed as follows. Review any additional written comments on the nomination that have been received by the committee. Vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 35 days from the date of the governor's written notice. The hearing by the Joint Standing Committee on Veterans and Legal Affairs for Ms. Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to take the vote immediately. Are there any objections? Seeing no objections, the pending question before the committee is that the Joint Standing Committee on Veterans and Legal Affairs recommend to the Senate of the 130th Maine Legislature that the nomination of Ms. Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. The vote of yes will be in favor of recommending confirmation. The vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Senator Hickman,
Yay.
Senator Hickman, yay. Senator Marmont,
Yay.
Senator Marmont, yay. Senator Farren,
Yay.
Senator Farren, yay. Representative Ciazzo is absent. Representative Riley,
Yay.
Representative Riley, yay. Representative McCray,
Yes.
Representative McCray, yes. Representative Supika,
Yay.
Representative Supika, yay. Representative Wood,
Yes.
Representative Wood, yes. Representative Kinney,
Yes.
Representative Kinney, yes. Representative Harrington is absent. Representative Corey is absent, and Representative Dahl is absent. That's 8 in the affirmative, 0 in the negative, and 4 absent.
Thank you, Darlene. 8 members of the committee having voted in the affirmative, 0 in the negative. It is the vote of the Joint Standing Committee on Veterans and Legal Affairs that the nomination of Ms. Stacy D. Newman, Esquire of Scarborough, for appointment to the Commission on Governmental Ethics and Election Practices be confirmed. Congratulations. Thank you very much for stepping up to serve in this very important role.
Thank you. Thank you all.
You're welcome. And Darlene, I'm here so I can sign the document and we can get that off to the Senate for the calendar for confirmation. With that, our work this morning on this confirmation hearing is complete. We will return no sooner than 10:30 to begin and end our final work session of the session. Thank you all for being here today. Thank you, Mr. Bushy.
Thank you.
Enjoy.
Great to see you all.
Thank you.
Thank you all. Have a great day.
And Darlene, we have a different room for the work session, correct?
No, same room.
Same, this is the
link.
same Zoom, same link, same
Yep.
everything? Okay, great.
Once we started in the morning, it stays all day.
Just wanted to make sure that we didn't have to have something different for work session, so this is fine. I won't close this out.
Okay.
Really, then
Please don't.
I'm gonna open up the my caucus, my personal chat room. If you want to come and caucus about what we're gonna do this afternoon, I'll see you shortly. Thank you all.
Um,
Hey, Darlene,
what?
can you put yourself on mute?
Yep.
Thank you.
You're welcome. The minute you said, hey, Darlene, I knew what you were gonna say.
Yeah, just don't tell them where to go. Yeah, no problem. Like my bright yellow shirt.
I almost wore bright yellow
Pride.
too. I just sent you an email if you have a chance to review it later today, Senator.
Oh, on 1750. Yeah, I had a I've actually got that, and I brought it with me, my stuff from ranking. I got that. That's on my to-do list. What did I have for comment? Where did I write it down?
Just for committee members to know, we are streaming live. So any of your conversations are happening in real time out in the world. When we have 7 committee members present, we will sort of begin again through committee introductions and then open the work session that we had. 10:35, we should be getting started here shortly. 1, 2, 3, 4, 5, 6. We need to see 2 more faces from our committee members. If they can hear me or see me, please join us. 1, 2, 3, 4, 5. Great. 1 more person and we can start. And I will ask everyone to mute themselves if you've not already. So there's no inadvertent, too much information going live. All right.
Or not enough.
Okay. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. We will begin our work for this late morning and early afternoon momentarily. But first, we'll do committee introductions all over again. We had a confirmation hearing earlier, but I consider this work separate from that. So with that, I'll begin with Representative McCright.
Thank you, Mr. Chair. Mr. Chair, this is Jay McCright. I represent Harpswell, West Bath, and Northeast Brunswick in the House, and I'm trying to multitask.
Senator Miramont.
Hi, Dave Miramont, representing Senate District 12, Knox County. Nice to be back.
Senator Farron.
Good mid-morning. Brad Farron, live in Norwich Walk, represent Senate District 3, which is the majority of Somerset County. And I was just going to make a comment that it appeared that Senator Miramont's head was in the clouds with that picture right behind him, but he missed it.
Representative Wood.
Thank you. Hi, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of Westbrook.
Representative Supika.
Hi, I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Kinney. Okay.
Okay, did that work?
Yeah.
I'm having technical difficulties. I'm Mary Ann Kinney. Oh,
We can hear you.
okay. I'm getting feedback here. Yeah, Mary Ann Kinney, I represent House District 99 in Western Waldo County, and I apologize. I'm working and trying to do different things all at the same time. Made it to my office though, and that's working again. I'm excited.
And I'm Craig Hickman. I represent Senate District 14, 11 towns in Southern Kennebec County, including my hometown of Winthrop. We also have with us today Darlene Semino, who will be our clerk, and we have Janet Stocco, our awesome analyst, who is going to help us dive in to the work in front of us. So with that, without further ado, I will open the work session on LD 2029, an act to enhance the prevention of and response to sexual assault and sexual harassment in the Maine National Guard, which is a committee bill of the Veterans and Legal Affairs Committee. Janet, please present your analysis.
As Senator Hickman said, this is a committee bill. It has a long history. So there was a report from 2014 that had some recommendations about the whether Maine law has adequate prosecution of sexual assault in the Maine National Guard and treatment for military victims of sexual assault. And then last year, you all passed Resolve 2021, Chapter 21, which directed a review of the implementation of the recommendations from that 2014 report. You had that new report from the new Resolve presented to you earlier this month, and then reported out a bill, and that's the bill that we're talking about today. The first part, Part A of the bill, requires the Adjutant General to provide for a thorough review of the manner in which reports of sexual assault are investigated, prosecuted, and adjudicated by the Maine National Guard. That report, that independent review and report would either come from the National Guard Bureau Office of Complex Investigations or an independent agency. As part of that review process, the bill provides that to the greatest extent allowed under state and federal law and in a manner that protects the privacy of victims, certain information has to be provided to the reviewer, including policies, procedures, and records related to sexual assault and sexual harassment, the results of climate command surveys and then unit risk inventory surveys, as well as any other materials that are requested by the reviewer. In addition, the Part A of the bill requires the Adjutant General to submit a copy of the report of the independent review, including any recommendations to this committee next February, and authorizes this committee or a successor to report out legislation in 2023. As we talked about at the first work session, Representative Riley has proposed an amendment that would direct the Office of the Attorney General to conduct the independent review. He didn't suggest that that be the outcome. He just proposed that that was an alternative approach that the committee might consider. And he left it for you all to discuss which approach you preferred better. In addition, the Adjutant General's testimony indicated that climate command surveys are confidential under federal law. Some follow-up information has provided suggestions about how to address the confidentiality of those surveys and ensure information can be shared but in accordance with applicable federal regulations. And then I did note that in drafting this bill really quickly, as you know, it was a quick process. I think that the independent review, I think you intended it to be both about sexual assault response and sexual harassment response in the National Guard. If so, then we need to add that phrase to the first sentence. And then just yesterday, after this bill analysis was prepared, you received further information from the Adjutant General, and then a copy of the letter this morning indicating that the Office of Complex Investigations, there had been some question whether they could perform this review, and it sounds like they can perform a review. I don't know if it's exactly to the same extent, but that's just follow-up information that wasn't available when this was written. Under Part B of the bill, it addresses National Guard commanding officers' orders to cease harassment. So in sections B2 and B5, there's an amendment to the criminal code, which establishes the crime of harassment. And it, as that amendment is drafted in the bill, it would provide that a person is guilty of the crime of harassment if that person engages in any course of conduct with the intent to harass, torment, or threaten another person, and during the previous year the person who's doing the course of conduct, while a member of the Maine National Guard, was notified in writing or otherwise not to engage in that kind of conduct by a commanding officer. And this crime will be committed regardless of whether the person remains a member of the National Guard when the conduct occurs and regardless of where the conduct occurs. Just so that you know, harassment, although you can't tell from the bill, is generally a Class E crime punishable by up to 6 months imprisonment and $1,000 fine, except that if the defendant has 2 or more prior convictions for harassment against the same victim or a member of that victim's immediate family, then harassment is elevated to a Class C crime, which is punishable by up to 5 years imprisonment and a $5,000 fine. Now, I have a somewhat confusing technical question to you all here, but I did think it was important to raise just to see what you all thought. So as I understand it, this part of the bill is designed to make sure that when a commanding officer in the National Guard orders someone in the National Guard to cease harassing someone else, that order would have the same effect as if a law enforcement officer had issued that order, if those folks happen to not be on National Guard duty or National Guard property at the time that the order was issued. So the bill takes care of allowing the orders to have the same effect by saying that if you get that order and you then violate it, you could be guilty of the crime of harassment. But there's another effect that law enforcement officers' orders have, and it's a little bit complicated to explain, but I'm going to try and explain it a little bit clearly. So you may all be aware that there is a court process to seek a protection from harassment order. And several years ago, there was a study conducted in which, and that study actually led to that review process for judicial priority proceedings that we went through for a different bill in this committee. That was one of the things that study did. It looked at all of the ways to get into court and expedited proceedings, et cetera, and so forth. One of the things that study did was it said, yes, if you're going to expedite court proceedings, please have the Judiciary Committee review it. You're familiar with that part. Another thing that study did was it proposed a little bit of a limitation on entering the courthouse door to seek a protection from harassment order. So protection from harassment order is available if the plaintiff is able to prove that the defendant, quote unquote, harassed the plaintiff. And harassment is defined in many different ways, including committing 3 or more acts of intimidation, confrontation, physical force, or the threat of physical force. But the group and then the statute was amended to provide that just merely alleging that isn't sufficient to get to seek the order to file a complaint. So instead, if you want to file a complaint, you have to allege that the defendant committed a single act or course of conduct that constitutes one of a list of crimes. Those crimes include things like assault or domestic violence assault, sexual assault, a whole bunch of different types of specific crimes. So you can allege that in your complaint, or you can allege that the defendant engaged in domestic violence, violence against a dating partner, sexual assault, stalking, or this crime of harassment we've talked about that's in the bill. Or you can say if the 3 or more acts of intimidation you're talking about don't fall into these 2 definitions, you could instead say, well, this person was harassing me. I got law enforcement to issue them a notice to stop harassing me. And I think it's important enough that I'm going to go forward and ask the court to issue an order as well. And so that's the other effect that those law enforcement orders have. And why does this matter? Well, you heard about the crime of harassment, which provides it's a Class E crime after being given that order to continue to engage in the course of conduct. But that's the only thing about the crime of harassment. If you get a court order, you can get some other types of remedies, including the court could order the defendant not to have any direct or indirect contact with the plaintiff, so that's broader. Also, not to go on the property of the victim's residence, not to interfere with or destroy the victim's property, not to follow the victim without reasonable cause, or be in the vicinity of the plaintiff's home, school, or place of employment without reasonable cause. And if the court does issue a protection from harassment order, then any violations of that order, as long as they're not just merely monetary violations, are Class D crimes. So I just didn't know the way the bill is drafted, it just gives the National Guard commanding officers cease harassment order the effect of being a predicate to the crime of harassment. And I didn't know if you also wanted it to be a predicate to seeking a protection from harassment order. Hopefully that makes sense. Yes, Representative McCray, can I have her ask her question?
I was going to say, Janet, thank you very much. I know that we have asked the district attorney from Kennebec County to be with us today on some questions that we had prepared. I may invite Megan Maloney into the panel to discuss this section. And of course, the Attorney General's office is also, the Attorney General and his office are here. So before I invite them in to deal with this part, which will probably segue into another suggestion that I have for amending any part of the criminal code, I will call upon Representative McCray.
Thank you, Mr. Chair. I think this is a simpler question, I hope. Janet, can you back up to the beginning where you're talking about harassment further up? My question is, I'm looking at the proposed committee bill from 314. Is that what we're going from? And I'm just looking at Part B where it talks about harassment and it talks about the sheriff, deputy sheriff, constable under A, 1A, smaller A. Is that changed in what you were describing?
So this is the crime of harassment in the criminal code currently.
Okay.
So if we're just looking at what the bill does, is it amends this section. So right now you're guilty of harassment if without reasonable cause you engage in this course of conduct with the intent to harass, torment, or threaten another person, and one of these law enforcement officials has notified you to not engage in that contact, and they've notified you within the prior year, or you have a protection from harassment order or protection from abuse order, or you're in the Department of Corrections and you have been ordered not to continue your conduct there. What the bill does as it's written currently is it adds to this that you engage in the course of conduct after having been notified by your commanding officer while you're a member of the National Guard to cease harassment. And then that notice would remain in effect even if you then leave the National Guard or you are engaging in conduct that not during your active part of your National Guard service. But again, the order would expire 1 year later. So that's what is in the bill. And my question was whether, because the cease harassment notice, sorry, I'm navigating around, but if you file a complaint for a protection from harassment order, sorry, I'm not finding where it is. Anyway, I'll just go back to the bill analysis. It's there. If you file a complaint for a court order of protection from harassment, having that law enforcement notice can help get you in the courthouse door. And I just didn't know if you had all intended for these orders from the National Guard commanding officers to have the same effect as law enforcement orders. Do you also want that notice to be a way to get in the courthouse door for a protection from harassment proceeding?
Thank you, Janet. That's very helpful.
So that is the question for the committee. And I would like to invite the district attorney for Kennebec and Somerset County.
Do you want me to stop sharing so you can see her?
I can see her, thank you. And you can stop sharing for a second when she gets here so we can all see her. Good morning, District Attorney Maloney. Please introduce yourself.
Good morning, Chair Hickman and honorable members of the Veterans and Legal Affairs Committee. My name is Megan Maloney. I'm the District Attorney for Somerset and Kennebec counties.
Thank you for being here. I guess in some ways I'm putting you on the spot as you help this committee through the uncharted waters that we are in here in the state of Maine. And I know that your office deals with the issues that were just on the screen. So first, can you just walk us through what you see around this and whether or not you have any opinions on the question that our analyst has asked the committee to consider?
Well, thank you. I do appreciate the explanation that your analyst just provided. I thought she did an excellent job. It really is a policy question. My opinion would be that given that the current statute allows for a law enforcement officer to serve a notice to cease harassment as both a predicate to criminal filings and to enable the victim to get in the courthouse doors to get that protection from harassment order, that a National Guard member would be given the same authority. So that makes sense to me, that if we're giving that authority to the National Guard officer, that we would give the same authority that's given to law enforcement to that officer. And so I think it's makes a lot of sense.
Thank you for that. Are there any questions? Chair recognizes Senator Farron.
Thank you, Mr. Chair. Thank you. Megan, how are you? Always good to see you. We don't get to see you.
Good to see you.
Exactly. Any concerns? One of the things that the committee's talked about, and maybe this, you're not the right person to answer this or not, I don't know, but we've talked about statuses, right, with National Guard members, and some of the language in here is about even when if they cease to be a National Guard member, we know that some of that authority of a commander in the status, whether it's Title 10 or Title 32 or drill status or whatever it is, any concerns or thoughts about how that control or that authority is carried over if we put it into the statute?
That is an interesting question. So I thank you for that question. I was with a committee when this provision of requiring a law enforcement notice was added to the statute. So it is it is a piece that didn't initially exist. So if you're looking at the statute, it's 506-A, capital A, subsection 1, subsection A. And that's where we're talking about any sheriff, deputy sheriff, constable, police officer, or justice of the peace being able to give the notice in writing. That piece was added as really at noticing what was happening in the court system, and with both the court system overwhelmed by the number of cases and with victims wanting an intermediary approach to not have to go to court if a notice alone would be enough to stop the harassment. So it was both kind of coming together at that committee, proposing this language and then it being added to the statute. Given that background, I believe that the legislature has the authority to add whoever they wish to the group of people who can serve this notice to cease harassment. As far as the criminal statutes go, it's different, of course, as far as the military statutes go for looking at military rules and whether or not it's going to impact their time in the military. That would be a different set of calculations. But as far as the criminal statutes go, you're fully within your authority to decide who you want to give that power, where you've given it to sheriffs, deputy sheriffs, constables, and police officers and justices of the peace. You can expand that, which is essentially what I see you're doing in this proposal.
Thank you, District Attorney. Senator Farron, does that answer your question? Great. Are there any other questions for the District Attorney on this particular conversation? Seeing none. So Janet, I'm just going to jump ahead to page 7 of your analysis, the bottom, since we do have District Attorney with us. District Attorney, we did ask you to come with an answer to a couple of questions regarding how local law enforcement and the local district attorney's offices respond when receiving reports of alleged sexual assaults involving members of the Maine National Guard, and whether you are aware of any state court criminal convictions that have arisen out of sexual violence that have occurred within or between members of the Maine National Guard or members of the National Guard in any other state. Open-ended questions, but we felt like your expertise would be important for us as we consider our work.
Well, I thank you for the question. I did email the question to the district attorneys throughout the state. And we do have a meeting on Friday. At this time, I haven't received a response from anyone who is aware of a case of someone being sexually assaulted in the military, also proceeding in our criminal courts. Now, as I said, we do have a meeting on Friday. I have not had an opportunity to reach out to some of our retired district attorneys, and I am thinking that perhaps they would have some information that the currently serving district attorneys might not have. The difficulty with doing a search on this is it's not a searchable term because it's not a identified in the statute. So, for example, if you asked me how many cases of domestic violence did we have, because assault can be both assault or totally different statute number for domestic violence assault, I can just search that. But if it's a sexual assault by a member of the military, the statute doesn't change. It's the same statute, whether the person is a civilian or a member of the military. So I don't have a field for just searching our computer to get that information. And that's why I'm trying to rely on people's memories. Personally, I've served for 9 years now in my current capacity. I don't have a case in my district where we've had a case go forward because of an assault that took place at the National Guard Center. I do have cases against guardsmen and women that did not occur while they were serving, so that are separate from their service. So those I do have, just like I have cases against people in every profession.
I got you. I think I understand the answer to that question, and that will inform a question that I will have for TAG when the time arrives. Are there any, and thank you for that. If you get any feedback, please feel free to share it with Janet and the committee if anything comes up between now and then or thereafter. Are there any other questions for the district attorney from members of the committee? Well, thank you for participating and helping us out with this. If you are still on standby later, I will call upon you again, but I know that you have a very busy day. So
well, I'm happy to. It's extremely important. And I do serve on the board of the Sisters in Arms Center, okay, which is also involved with protecting victims of sexual assault in the military. So I am absolutely happy to be a part of this.
Thank you, District Attorney.
Thank you.
Chair recognizes Senator Miramont. He may have a question before you go.
Yes, thank you, Mr. Chair. Welcome, District Attorney Maloney. The question is, with the walls put up by federal government rules, how effective can you be even if we do ask more of you or the Attorney General's office? It seems like a moving target. It's like you think, well, they've said you can't do it this way. Then so you try to do it this way and they say, well, no, actually we can't do it that way either. We can't give you info. We can't do that. I mean, it's always a moving target. Do you think you can be effective, or the Attorney General's office can, if they were actually trying to?
Well, the whole question is access to information. So you're absolutely right to identify that as the key piece. The investigation could proceed with both a state actor investigator and a military investigator working in conjunction with one another. So that would be a possible way of getting the information if a state investigator were allowed to also participate in the investigation. If I have information, then I can proceed. But the key is getting the information. What makes this also particularly sensitive is sometimes victims don't want to have their cases prosecuted. And we are sensitive to that when it comes to sexual assault cases. And I understand that that can be because of worrying about repercussions upon yourself. And I wish that there were more opportunities for victims to explore what a criminal prosecution would look like without having to commit to going forward. So that's why I meet with victims anonymously to be able to answer their questions without their feeling like there's any pressure to go forward. But I think that is that can be a difficulty because, of course, we don't force victims to go forward with criminal prosecution unless they want to. So they may choose to want to go forward only through the military avenues and not want to have a public prosecution. If that's what they choose, then we do respect that request.
Thank you. The chair, is that answer your question, Senator Mimma?
Yes, that's enough for now, but it does. Thank you very much.
Great, thank you. I've promoted and welcomed General Farnham to our discussion on this issue as well. General, will you please introduce yourself for the record?
Good morning. Doug Farnham. I'm the Commissioner for the Department of Defense, Veterans and Emergency Management, and glad to be here again.
Thank you, sir. You'll see why I promoted you at this point in time.
Okay.
Early. My brain is working. It's on fire. This is a good thing. The chair recognizes Senator Farron.
Thank you, Mr. Chair. District Attorney, one of the questions that description or process that you just talked about, how sometimes victims don't want to be publicly out there, is that, my assumption is, and I guess we're looking for confidence, that's not just in military cases. I mean, is that, correct? I mean, you don't see that as an outlier just in that particular case. Is that a fair assessment?
100% correct. 100% correct. I talk to victims anonymously across the board, and sometimes they will simply thank me for the information, and I never know who I spoke with over the phone. And sometimes they will follow up with additional conversations and then decide to move forward. I had a case just in November that started with an anonymous conversation. So it's across the board. Extremely difficult topic for victims and an extremely difficult decision for them to decide whether they do want a criminal prosecution. It's hard to talk about publicly. That's really the bottom line. And so they want a greater understanding of what will happen in the criminal justice system. I can tell them what laws were violated. I can explain to them how the facts of their case intersect with the law. But of course, I can't give any assurance as to outcome. I can simply explain the process. So that's what I do.
Follow up, Mr. Chair.
May I proceed?
So one of the other things that I've heard, since this topic and Representative Riley has brought this forward and we've heard from things, I think we've all been having conversations with folks potentially impacted. And one of the frustrations that I heard Friday and then this weekend from some of the survivors were that they didn't feel that appropriate actions were taken as things move forward. And part of that privacy piece is, and I'm asking you as a district attorney, you can't necessarily share all that because at the time, you don't want to show your hand because if more evidence or more allegations come down the road, you can have that. So that whole confidentiality piece is a juggling act. And I don't know how you do that.
Right. It certainly is true that everything is confidential until that first court document is filed. Right. So throughout the investigation, I'm not allowed to talk about anything. And so it's only once that first criminal complaint is filed with the court that the public becomes aware of anything happening. And yeah, it is very difficult to talk about because of the confidentiality. That's true.
Last question, Mr. Chair.
You may proceed.
Switching on your sister in arms hat from that standpoint, thank you for the work that you do with that piece. Have you had a chance to take a look at the governor's executive order that you put out, and from wearing that hat, what are your thoughts about that?
I have read the governor's executive order, and I think it's a good way to proceed. It will enable a group of people to come together and really look at this issue in depthly to see what more can we do to help victims become survivors. What more can we do to hold people accountable? And it looks like there's a wide array of people who will be represented. And I'm certainly happy to be a part of that.
Thank you. Thank you very much. I really appreciate and value your opinion. So thank you very much.
Thank you.
Thank you, DA. We have Chair recognizes Senator Mirmont.
Thank you, Mr. Chair. And I see with General Farnham here, the couple questions. Where do you work out of, Augusta or Bangor, General?
My office is in Augusta.
It is. So you probably work with District Attorney Maloney or have worked on issues regarding this?
I think our Provost Marshal and our JAGs have worked not necessarily with her, but with her folks. I'm positive of it.
So I'm trying to think of a situation that comes up. Would it be, so it wouldn't be at the top with either of you two necessarily to begin with, but it would be in your chain of command in both offices. Would it ever be that just the same as the person complaining has to complain to her superior, who may be the harasser or assaulter? Is that the right word? But anyway, so that it can't get anywhere, or that they're superior to the person who is the harasser is part of kind of keeping it quiet, so that the person from the DA's office is only talking to someone who's really part of not wanting this to go very far, as opposed to you, who sounded so sincere in being gut punched by some of the stories last week, that it never rises to you and it never rises to the DA, and you guys aren't talking. And it isn't even that you're trying to say, well, I can't tell you because it's all a secret. It's that it doesn't even rise to that level of people who really want this solved.
Yeah, no, sir. I think we're kind of mixing a couple of different things here. But when it comes to, again, like we've talked about before, is when the cases first come forward, they're first offered to local law enforcement to do the investigation and do the whole piece. And that may be the victim at that time is probably talking to a victim advocate in the sexual assault response program. They may already be assigned a victim. If they're going to go through law enforcement and make it an unrestricted report, they're working with their special victims counsel, a JAG that specializes in that type of thing. And those are the folks, along with our Provost Marshal, that is now that elevated position we've talked about. Those are the folks that are working with law enforcement to move forward. So it doesn't go through the chain of command necessarily initially. The chain of command has been notified that there's a case, and depending on the circumstances, we may know more or less about it, depending on the desires of the victim. You alluded before about all the federal things that get in the way of sharing. There is nothing that gets in the way of sharing everything we know, every bit of evidence that we have in the law enforcement with an unrestricted case, with doing everything we can do to go through that law enforcement and prosecution. There is nothing federally that gets in the way of that piece. Any of the conversations we have about not sharing information or privacy are the same types of concerns that the sister in arms have when a victim comes to them, and what they feel comfortable sharing with other people to protect re-traumatizing victims and what the victims want, or letting other, like we've talked about, I think on Friday a little bit, about having other folks in the organization know that they're making a complaint, and so that there's no retribution and that type of thing. When we talk about the federal rules that we have on sharing information and privacy, that's what we're talking about. But make no mistake, if we're talking law enforcement and we're talking prosecution, we are 100% sharing everything that we have.
We're also allowed to share with other investigatory agencies. I can't share publicly until that complaint is filed in court. But with another agency that's investigating, that is an agency that I can share with. And the victim, of course, is always allowed to speak to whoever he or she wants to speak to. So if the victim wants to speak to me and to speak with General Farnham, that's fine. There's no sort of confidentiality around who the victim can speak to. The victim's allowed to speak to whoever that person chooses.
Follow up, please.
You may proceed.
Yes, thank you. And so another part of the testimony the other day was that when someone from the Guard might go to non-military law enforcement with a problem, that law enforcement might say or might think, this is a military matter, we're really not going to do much. The MPs will take care of it or something like that. So they're not getting served by either party that they're trying to get help from. When they say law enforcement has that attitude, their initial complaint to civil law enforcement would not rise to your office unless that law enforcement chose to bring it to your office or the person complaining brought it to your office. So there's really another way for this to not be dealt with. And I didn't make this up. It was part of the testimony. And I think it was from the general saying that law enforcement might treat it that way, and another way that these people aren't being helped. Is that kind of a fair assessment?
Sir, can I add a little context before the response? Just to help out. I said that, and I use that as an example of what I was concerned with when this topic first got being talked about. We heard from victims that they didn't, that they felt that they weren't getting the full attention of local law enforcement. So that was one of my concerns. And is it possible that that's what they think? So in my learning and in my asking questions, I became convinced that there was no issue with local law enforcement thinking that way. But what was missing was that communication between local law enforcement and our JAGs and our victims councils and our victim advocates, our commanders and the victims, that was truly the case. And that's where so I was using that example as why I thought our Provost Marshal program was so important, because that is the person that is facilitating all those conversations. So there is transparency amongst the people that are involved, and we can confidently say that law enforcement is absolutely doing their job, making very difficult decisions at times on what they need to do moving forward, but that they're doing it not with some misinformation about what will happen to them on the military side. So that's the full context of my comment. So hope that helps.
Thank you, General, for that context. It is helpful. We will certainly hear later from the Office of the Attorney General about a recommendation that is already in the amendment, and we'll discuss more about that communication, collaboration, review on civilian law enforcement working with military law enforcement in investigating and perhaps prosecuting crimes outside of an administrative procedure. But Janet, can you please bring up the Title 37B?
And Mr. Chair, I think District Attorney Maloney wanted to answer part of that too.
Everybody hold on tight.
All right.
I'm trying to do something that it's germane to what we're talking about. Janet, can you please bring up Title 37B, Section 461? Please, it is part of the main Code of Military Justice. And while you're bringing that up, the chair recognizes DA Maloney.
Thank you. I just wanted to respond as far as sexual assault investigations in my office come in through a process that we call review. So law enforcement rarely arrests a person once an sexual assault complaint is made. Generally speaking, a full investigation is done through several conversations with my office. Whoever will be the attorney assigned to that case is the person who works with the law enforcement officer. All of the information is gathered, and then a decision is made whether to request an arrest warrant or whether to bring the information to grand jury or whether to decline the case. So with and that goes across the board. Wherever the crime occurs, it's going to start with this review process with local law enforcement working directly with my office.
Thank you. So here on our screen is Section 461 of Chapter 5 under Title 37B, the main Code of Military Justice. And in it, there is a section toward the bottom of the code on sexual assault. It says prohibition, sexual assault. Any person subject to this code, which is the main Code of Military Justice, who commits an offense prohibited under Title 17A, Chapter 11, is guilty of that offense under this code. Punishment. Any person found guilty of an offense prohibited under Title 17A, Chapter 11 must be punished as a court-martial may direct. General Farnham, are you aware of anyone being found guilty and punished by a court-martial under this provision of law?
No, we don't. We do not do court martials in the state, which is that's why we leave it to local law enforcement as a matter of rule and policy.
So this has been in the law since 2013. It looks like it was new. How can, if you're not doing any punishment by court martial, can you tell me why this is here? Is it just defunct? Is it inactive? What? Who enforces this part of our of Title 37B, Chapter 5?
I'm gonna have the JAG come on if you don't mind. That's
yeah. And in the meanwhile, Janet, thank you for sharing the screen. Back to the bill at hand. The part that is amending the harassment statute in Title 17A, Section 506A. General Farnham, do you have any opinion about adding the language? Janet, can you put the language back up on the screen that we would be adding to 506A that would include the National Guard as a person listed?
Are you asking for the bill?
I'm asking for the part of the bill that amends the section that we are talking about here. Yes, I am. So, yes. Section B4, 17A, 506A, subsection 1, we would be adding a third subsection To that, General Farnham, I just wanted your opinion about whether or not you think this is a good idea to make the harassment statute strengthened in this way.
No, we have no objective to that. And just again, just to add a little context, currently in order to help get that order, our victim advocates or the victims counsel, special victims counsel, help the victim navigate through that system. But as has been mentioned before, it can be a little re-traumatizing, a difficult process to go through, which is why the thought process being that if we could take the order that was given by the commander and extend that out to apply more broadly, as was the goal of this, that was a good thing, because it was potentially one less step for the victim to have to go through in order to have the same effect and have that order that the commander made apply more than just on our facilities.
Thank you, sir. And so, Janet, based upon the discussion that we're having, the questions that you have asked in your bill analysis, are they being answered? I mean, I know it's a policy decision of the committee, but are you getting clarity around an answer to your question? At least what the committee must consider to make this law tight?
I think it is purely a policy question. The bill proposes to have the commanding officer's order have the effect of being a predicate for the criminal prosecution for harassment. And the question then is whether you also want it to have the effect of being another avenue to enter the courthouse door to get a protection from harassment order. And that's really up to you all. I don't have a question to ask about that, other than when you vote, you should decide whether you want to include that.
So I'm gonna, can you please stop sharing your screen? Thank you, Janet, very much. Chair recognizes Senator Mirmont.
Thank you, Mr. Chair. So, but that does not preclude something being initiated without the commander having given the warning first. It's just another way that you can do it, right?
Right. So if for example, the allegation is that there was a sexual assault, that one act is one of the enumerated crimes that you could allege in your complaint, and that would get you into the courthouse door. But if it's more of a course of conduct, like 3 or more incidents, and they don't, maybe more of a sexual harassment nature, they don't rise to the level of an actual crime, then this order you could have in your hand and say, you know, it was serious enough that I got this order. And that's sort of the design of the protection from harassment statute. You got that order from law enforcement. Here you would be adding, if you vote to, you got this order from the commanding officer. And that's a way to then get into the courthouse door, prove your harassment case, or maybe not prove it, and get an order from the court as well.
Thank you. So for committee members, as we go about our business today, make sure you keep in mind this section. We're only on page 2 of the bill analysis, which is fine. Before we move past this particular part of the analysis, General Farnham, did you have someone here that can just tell me why we don't enforce Title Subchapter 5? Thank you. Welcome.
Hello, I'm Major Katie Trost. I'm one of the judge advocates here. So big picture, we added that in 2013 as an enumerated offense. We have a list of specific military offenses. We don't do courts martial because, as we've discussed before, we don't have organic criminal investigatory capability. So what we have is a provision that allows us to take action of something, but no way to get the information. In terms of having a court martial, if law enforcement investigates something that meets that definition, likely it will go to the district attorney and proceed through criminal channels. I wasn't here in 2013. I suspect the reason we added it was for our non-judicial punishment, which is our more administrative punishment capability. And we would then be able to use that conduct to potentially reduce somebody in rank. And we talked a little bit before, most likely in order to impact retirement benefits, if that makes sense.
It does. So my question becomes then, if we were to strengthen Title 506, 17A 506, and this is a question for anyone in the unit, if that is the way in which that provision of the Maine Code of Military Justice is currently used, would you have any objection to us amending it to include harassment as one of the considerations for some type of administrative review?
I'm going to give that to General Farnham for the opinion piece. I will say though, in practice, I'm going to take you down a little bit of a rabbit hole. A lot of what we do now involves what we call general articles, which is conduct prejudicial to court order and discipline, or service discrediting. So by kind of really strengthening that part of our conduct management, we haven't historically had to use enumerated offensive very frequently.
Okay.
Does that make sense? So basically, if you have any sort of guard to guard interaction, likely we're going to be able to encompass that in our more general conduct issues versus looking to specific enumerated offenses. And that could be for anything, if that makes sense.
The chair recognizes Senator Mirmont, who has a question.
Thank you, Mr. Chair. Would that have an equivalent punishment or consequences if you put it under a different one that didn't need an enumerated offense?
No, the punishment capability is the same. So it's going to be a substantiated military. It's a weird hybrid of criminal and admin capability, but there's no special punishment different from the process that we use, which is that non-judicial punishment.
Thank you.
Thank you. General Farnham, if you would opine on my question regarding a similar provision in the Maine Code of Military Justice that would include harassment in addition to sexual assault.
I don't think it would hurt anything. I don't know that it changes a whole lot because of the way we go through the local law enforcement and civilian prosecution is the way we do the criminal parts of it. So off the top of my head, I can't say that it would change a lot. Now, it may align us closer to what is happening on the federal level, because you may have recognized back in January, February timeframe, the president had an executive order that said sexual harassment was a crime, and then that's written in the NDAA. And how that's going to be interpreted, there's a lot of question in the National Guard in whole, because every state has different laws and definitions in the area of harassment and assault, and so now in the UCMJ and in the active duty side of the house, we're saying sexual harassment is a crime. Yet all the states that go through local law enforcement, that may or may not be in their local local criminal statutes. So the Guard Bureau right now is trying to sort all of that out and figure out on the National Guard side how that intent is going to be implemented. So having sexual harassment added, I don't think hurts anything, because it may just align us with whatever comes out in the future, even though we don't know exactly what that's going to be. I wish I could answer it better, but
that answers my question.
Okay.
Straightforward. Harassment is a crime under Maine Code. There is this reference to another crime in the Maine Military Code, and so I actually agree with you that it doesn't hurt. It's a belt and suspender approach to make sure that it's clear when reading it that it's considered an enumerated offense, according to what your JAG just said. Let's see, I see that District Attorney Maloney has made a comment. We don't really use chats for comments. I didn't say that earlier, so can you please just tell us, District Attorney, what you are saying for the record?
Certainly. I apologize. I didn't want to interrupt. I just wanted to be sure that the committee knew that every complaint of sexual assault that is made to law enforcement does get referred to the district attorney's office. So, and that's the process that I referred to, that I described earlier. I don't think I was clear enough in saying they all come. All of them by statute. It's required that we receive them all. So even if it's a case that local law enforcement doesn't think is appropriate for prosecution, it will still come into my office in this review process. and we can agree or disagree.
Great. Thank you for that. So we will move past this part of our bill analysis. It's 11:30. We do intend to take a break at noon so that folks can get something to eat, and then we'll return and work until we need to take another break or until we're finished, whichever comes first. I will ask everyone to stay on standby who is here to provide information and to answer our questions. So Janet, if you could please return to your bill analysis and continue past, I think we're going to begin on the Maine Commission on Domestic and Sexual Abuse part of the legislation. And we'll see if we need to be nimble and who we ask to come forward and answer our questions. Thank you.
Certainly. So sections B6 to B8 of the bill amend the statute for the Maine Commission on Domestic and Sexual Abuse to add a member of the Maine National Guard with experience in sexual assault response to that commission. The way that it's drafted, it says that the Adjutant General selects that person. Representative Riley's proposed amendment would provide that it's the governor who selects the person, not the Adjutant General. Lucia Hunt, who is the chair of this commission, provided testimony agreeing that the governor should be the one appointing that person. And she also suggested that the committee consider whether to amend other portions of the statute so that the 36-member commission wouldn't now be a 37-member commission. And also that the committee consider changing the language describing the person who's being appointed. So it wouldn't say a representative of the National Guard, but instead would say a member of the military community. And attached to the bill analysis, I can scroll to it if you want, but there are certain provisions of the statute for the Commission on Domestic and Sexual Abuse that outline the membership. And there's up to 4 members at large appointed by the governor currently, and up to 4 members representing underserved populations that are appointed by the governor currently. And the suggestion was made, I think, by Senator Hickman, actually, that maybe those are 2 areas where you could reduce one of them to 3 members and add the National Guard or military community member there instead. I mean, you wouldn't put it there, but by reducing those to 3, you wouldn't increase the size of commission anymore.
Are there any comments or questions from the committee regarding this section of the bill? Something, of course, to think about if we're going to do it, how to do it. These are the suggested ways to do it. Seeing no questions or comments, moving along.
So section B9 of the bill provides, or excuse me, requires the Adjutant General to provide current and former members of the Maine National Guard who were the victims of sexual assault or sexual harassment while they were members of the National Guard. So that the requirement is to provide those individuals financial assistance to cover the expenses of traveling to and from and participating in proceedings related to that sexual assault or sexual harassment, and the following types of proceedings: state court criminal proceedings, state court civil proceedings, or proceedings under the Maine Code of Military Justice. And the Adjutant General's testimony requested that the language be clarified to reflect that the funds are for reimbursements related to military administrative processes or Maine Code of Military Justice proceedings. You'll see that a follow-up question was sent. It wasn't clear to me whether the testimony was to only cover those military proceedings, or whether it was just that the language wasn't clear enough that those military proceedings were covered. And I think the answer, although the Adjutant General is here, so you can correct me if I'm wrong, I think the answer was more the latter, to focus on the travel reimbursement for those military administrative proceedings specifically.
Thank
But
you.
obviously that's a question for you all.
Thank you, Janet. Can you please stop sharing your screen? Thank you very much. General Farnham, can you please comment on your clarification and then tell us about what kinds of resources you currently have or would need to achieve this?
So I think that was our clarification, is if we're talking about providing for all cases, that kind of comes into, again, you got to remember sometimes the victims or the perpetrators are not military. It's not military related. It's just one of our members. And so the question really is, what would happen if they were pure civilian as far as reimbursements to go to a county, county proceedings or whatever else. I have no idea what that would cost, because if there was no nexus to the military or military service, we're not sure what the limits on that. Now, when it comes to our own proceedings, we do have the ability to do that, where we put them on state active duty, and any former member, even if they're a former member, we can put them on state active duty, and then we can pay their travel and pay days and that type of thing. And we can currently do that. So that part of it's not a problem. If you start talking about cases that are outside of our own processes, then I don't know where the limits to that are, and then I can't even guess what kind of financial requirement that is. And again, it's not federal funds; it ends up being state active duty, state funds.
Are there any questions from the committee about this? Chair recognizes Representative Craig.
Thank you, Mr. Chair. Thank you, General Farnham. You probably said this, but just to clarify, for example, if both members would be military from what you described, right? So if it's a Guard member assaulted by a non-military person, they would go through law enforcement, and the Guard would not be doing the process. Is that right?
Well, even guard to guard members, if it's a county prosecution, civil criminal prosecution, which it could be, then that's where we're in that gray area that I don't know what would happen. Again, it's being done in the civil courts. I'm not sure what our basis would be to be providing the paydays and the travel and all that kind of stuff. Because again, then we start talking about nexus to the military. They may know each other. They may both be in the Guard, and they didn't even know they were both in the Guard, but they happen to be, at some event mid-month, and that's the part that gets really kind of gray. What is not a problem is when it's one of our own proceedings and we're having a separation hearing or anything else related to those cases that we're running, then we can put them on state active duty and cover it. It's when it's in the civilian realm that it gets kind of gray as far as what really are the limits that we're talking about. To just say any military member who's involved in civil proceedings that we're going to pay for their travel and their paydays, that's a little broad and probably not appropriate. So where those boundaries are would be the question that we have.
And General, can you explain what it means to be, quote, put on state active duty?
Well, right now the governor actually has the ability to we call it put on active duty. Basically, write a military order saying you are in state active duty status on X dates, and that means that you're eligible for pay that's commensurate with your last rank if you were a former member, and then the appropriate amount, travel pay and expense pay that would be if you were a current member. Very similar to if they were still in the military, but it's a state status because it has to be. That's the only status we can put them on. It's just a method to allow us to use funds to pay them.
Okay. So I'll claim complete ignorance about this. Does this mean that current members of the National Guard are not on state active duty? Unless
Correct.
they're on it? Okay.
Correct.
And maybe I misheard this when I was taking some testimony from survivors. It may have been that I heard that they are, once they make a complaint or file a report, that they are never put on state active duty, and then they need to pay for all of these expenses out of their own pockets.
No, I mean, when they first make the complaint, presumably they are they're still one of our members. So they're still a Title 32, Title 32 military member, which is a federal status, under state control, but it's a federal pay status. And so, I don't, that comment doesn't, I don't know what would be the reference of it. Now, again, a Title 32 traditional guard person, if they call up on a Wednesday and they start a process, they're not in a pay status. They are still Title 32 status, but provisions can be made to put them in training status, Title 32's training status, if they're current members, to go through a process, to have counseling sessions, whatever it is that is part of the going to be part of the process. If they're current members, we have the ability to put them in Title 32 pay status, and
in that status, they could get reimbursements for military administrative processes or the Maine Code of Military Justice Proceedings.
correct. Yes.
Is there a way? Is there a way under your command that it would be mandatory for any person who filed a complaint report that this is what they would receive, so that there wouldn't be discretion? It would just have to happen and they could expect it?
I don't think it's automatic. I think they would request it. You're talking about somebody who's actually left service?
No, someone who is currently in the Guard filing a complaint. Because if they've left service, then it sounds like it's a discretionary action to put them on state active duty in order to get these reimbursements. I'm just trying to make sure that if there is any grain of reality to a notion that a person who files a complaint can no longer receive any reimbursements for whatever reason, that's the case.
Yeah, that's just not true. And presumably, as they're going through the process, again, back to the perfect world, they're still a member of the organization and they're still coming to drill and doing pay days and annual training. They're still doing their training, or it can be put on orders for medical appointments or whatever else, which is the case. If it's a knee injury, or whatever else, if they're still current status, again, military nexus, that doesn't happen if if it's something that's not related to the military, but if it's a military nexus, that's not an issue.
So in section B9 of the bill, if it were to be amended to clarify what you are asking for it to be clarified to, then you would have the existing resources to provide that requirement.
Or at least, I think we do. Historically we have. We're not talking, we've got enough state active duty money to, it's not a lot of money. If it ended up being the type of thing where it was, expanded too much or interpreted that there was going to be, then that might be a different story. But for now, I have no issue with it at all.
Okay. Yeah, I'm asking the question under the constraints of the clarification that you have provided. Okay, great. Any other questions from the committee on this section of the analysis in the bill amendment as proposed? Seeing none, Janet, we can move on to the cooperative agreement section of your analysis.
So section B10 of the bill requires the Adjutant General to enter in a cooperative agreement with a statewide coalition against sexual assault that includes provisions requiring, on the one hand, the coalition to provide to the members of the Maine National Guard advocacy and support services for victims of sexual assault or sexual harassment, and a method for making anonymous reports to the Adjutant General of sexual assault or sexual harassment within the Maine National Guard. And then on the other hand, for the Adjutant General to provide to the coalition information on the unique needs of victims of sexual assault who are members of the National Guard, as well as, to the greatest extent allowed under state and federal law, and in a manner that protects the privacy of victims, certain information. And that information includes Maine National Guard policies, procedures, and records related to sexual assault and sexual harassment, as well as the results of climate command surveys and unit risk inventory surveys, and any other materials requested by the coalition. So that's how the bill is currently drafted. Representative Riley proposed amending this section to clarify that the information provided by the Adjutant General on the unique needs of victims is more about general information about the challenges faced by survivors who are members of National Guard generally, and not specific information about each specific victim's unique needs. In addition, Representative Riley's amendment proposes to replace the requirement in the bill that the coalition be requested to provide an annual report to the committee. So the way that the bill is drafted, there's this cooperative agreement that's entered, and then it says that the Adjutant General should request that the coalition provide the committee with a report. It's drafted that way because the coalition is not established by statute, so you can't order them to provide this report. So it's instead a request. So Representative Riley instead said, instead of doing that, requiring the Adjutant General to request this report, instead, there's another provision of the bill that requires the Adjutant General directly to report to the committee and include in that report information on what the coalition recommends for improving the National Guard's prevention of and response to sexual assault and sexual harassment. So it's just changing how the report gets to the committee. In the Adjutant General's testimony, there was an indication that command climate surveys are confidential under federal law, and that data shared with the coalition must be summarized to protect victim confidentiality. The follow-up information, the answers you received yesterday over email, they're posted online for people listening. This is the handout that had a lot of yellow highlighting on it. Those were the answers. There was information there suggesting some changes to the language about making sure that any sharing of command climate surveys, and that may be written wrong. I would make sure, I don't know if it's climate command or command climate, but we would make sure we write it the correct way. But the suggestion was to make sure that any sharing of that information comply, not just with federal law, but also with federal regulations, because there's a lot of regulations about the sharing of that information, and also being a little more specific about summarizing data if necessary to protect victim confidentiality. Former SARC Kartika Wright also had some recommendations in her written testimony, which was similar about protecting victim confidentiality and being careful what you share, because it may not be able to be shared under federal laws and federal regulations, as well as she questioned whether sharing climate surveys and unit risk inventories with the coalition would be helpful, because there's a lot of information that has nothing to do with sexual assault and sexual harassment in those surveys and inventories. And because they're not members of the military, she wondered whether the coalition would be able to really use that data appropriately and understand the implications of it. I don't want to really paraphrase her testimony anymore, but that was the sense I got out of her testimony on that point.
Thank you, Janet. And if you could please stop sharing your screen. Are there any questions or comments from the committee regarding this section of the bill? So my thought, this is a question that I would ask the committee and also even the general, if he would care to answer, is this perhaps something that could be studied by the advisory council instead of it being a requirement in statute? Or Representative Riley, since this is a bill that you drafted on behalf of the committee, if you could weigh in on sort of where you are at on being married to this being in statute or being a part of the advisory council, the scope of their work.
I mean, thank you, Mr. Chair. I mean, I would like to have it be in statute. I mean, what are you looking at for having it be in the advisory council? Would this be something that we would just change to direct the advisory council to look into?
That's probably what I'm thinking in my head, but I'm not suggesting that that's where I'm landing as a policy matter. It's just a question of these concerns are here, and I'm wondering how we would address them in the language. General Farnham, do you have any opinion about this section of the bill?
You know, you're going back to the, you know, the privacy and information sharing piece that we've, you know, is one of my is one of the things we talk about the most. And again, most of that is it's the professionals in the program that are the most concerned about sharing information because it's promises and commitments that they make to the victims as far as what they are going to share and what they're willing to share and protecting them as the best they can. I think you heard Elizabeth Saxel Ward when she said, there is information that if our member goes to her to share information and bring forward a case, there's information that she gets from our guard member, if she got it, that she can't even share with us unless she has it in writing. I think she said, unless she's got it specifically in writing from the person that she can share it with us. The folks in this business are very, very protective of the information and the privacy concerns. So that is that is my concern with that. And when we talked about our involvement with Mikasa, and I know we're not, and I get that why we don't put Mikasa in the language, but the concept here was that there is an awful lot of good work being done by a lot of organizations in this area. An incredible amount of effort and energy and surveys and studies that no one person has all that information. In DOD, the amount, and I've shared some of it with you, the amount of energy and work and studies and recommendations is just the amount of information that's out there is immense. And so the idea of making sure that we were working with Mikasa was so that our professionals who were involved would be as informed of all that's going on in the community and in the body of work as they possibly could be, beyond just what they're getting fed from DOD. At the same time, I am proud of the work and the effort that DOD has put into gathering information and coming up with recommendations. And I think that information that is shared by our folks to the other folks in Mikasa is a benefit to those organizations as well. And so that was the concept that we had with working with Mikasa, more than just, we thought the information sharing and privacy issues really were more about our report back to the legislature. Again, informed with information from Mikasa, don't have an issue with that. So that, I mean, it felt a little bit like we're mixing two things together in that thing. So that's, I guess that doesn't really answer your question, but that's kind of where I was coming from in that. So.
It's okay. And this is a work session for a reason. So are there...
I'm working, Senator.
The chair recognizes Representative McCray.
Thank you, Mr. Chair. I'm not sure I'm responding to your question directly, but it's just absolute that confidentiality has to be maintained. I don't think anybody argues that, and I appreciate that, General, that you're saying that, and Representative Riley. I had asked at the public hearing about data, and my interest is not absolutely protecting privacy, but making sure that we know we have the information about where the problems are and whether we've made progress. That's what I'm looking for. And however we do that, I mean, I do see that as a task of the advisory council. However, I would see us directing them with goals and maintaining confidentiality, absolutely. Making sure that we have what we need, whether it's through the climate surveys, and I think those are really important. But yes, you don't, maybe you don't need everything. You need the topic we're talking about, so that we know if we're progressing. And how we do that, I think that's a task of the advisory council. I think we're going to make some recommendations what needs to be included, but anyway, that's where I'm coming from. Thanks.
Thank you, Representative. Any other comments or questions about this part of the bill and the analysis to the bill before we take a break for lunch? Seeing none. So it is 2 minutes to noon, and I promise if we take a break for lunch, we will. We will take a half an hour break for lunch. If folks want to caucus, I'll turn on the link here. When we return from lunch, before we go through this in order, I like to be a little nimble. I'm going to ask for the researcher to present the research of the work done around this issue in 3 other states, I believe Alaska, Vermont, and Wisconsin. And then when we have that presentation, we will return to page 3, the bottom. We'll go through the advisory council. We will go through the annual report, and then we will finish, or not finish, we will then turn to the independent review by the Office of the Attorney General in Part A. I know that the Office of the Attorney General was here, and because that's just how we're going to do it. So we're going to start with the presentation of the research. We'll go through the rest of what's in front of us, and then we will end with the beginning of the analysis. That's our plan. Hopefully we'll be finished by dinner, but this is our last day of work. So I expect everyone to have cleared their day so that we can do the work that we need to do on this extremely important issue. So with that, the Joint Standing Committee on Veterans and Legal Affairs will be at ease until 12:30. Good afternoon. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. If you are a committee member, please turn on your cameras when you re-arrive. We began with the quorum, so we can continue forward without you, but we do want to see all of your beautiful faces. And I hope everyone had a good break and a good lunch. As I said before we left, we will begin this portion of our work session with a presentation on the research done by the Office of Policy and Legal Analysis. Kristen Braun, welcome to the committee. Please introduce yourself.
Thank you. Good afternoon. My name is Kristen Braun, and I am a researcher with the Office of Policy and Legal Analysis, and I provide research support to the VLA committee as well as other legislative committees.
Thank you for being here. I can attest to the excellence of Kristen Braun's research, as she did some for the Labor and Housing Committee last session. Pretty remarkable. And so with that, I will allow you to present your research, and whoever wants to share the screen, whether it's you or Janet, it doesn't matter to me, but take up to, I don't know, 15 minutes, I guess, if that's enough time. And
Sure.
If not, just keep going. Thank you.
Okay, I'll go ahead and share my screen. That's okay.
Yes, that is perfectly fine.
Okay, can everybody see that okay?
Yes, we can.
Okay. So this is the memo I put together on other states' independent reviews of their National Guards. And so I found 3 states, Alaska, Wisconsin, and Vermont, where the National Guard Bureau's Office of Complex Investigations conducted an independent review of those states' National Guard's policies and procedures. And that was at the request of either the state's governor or the Guard's adjutant general. And in addition to the OCI reviews, Alaska and Wisconsin state governments also conducted their own independent reviews. So first of all, I'll talk about Alaska. The first review that Alaska did was with the Office of Complex Investigations, and in 2014, the governor submitted a request that the OCI investigate open and closed investigations related to reports of sexual assault, rape, and fraud among members of the Alaska National Guard. And the request highlighted concerns over reports of sexual assault and allegations of a hostile work environment within the Alaska National Guard. And the governor's request also sought an overall assessment of the Guard's command structure and its responses in cases of sexual assault that were otherwise referred to law enforcement. So the NGB appointed an OCI assessment team, and this assessment team developed an action plan for its investigation, which included conducting a statewide command climate survey, collecting identified data requirements, conducting on-site interviews at all major Alaska National Guard locations, interviewing all senior leaders, and coordinating with the Criminal Investigation Division and local Alaskan law enforcement officials. In response to the allegations of sexual assault, the team focused on 4 areas: the review of reported allegations of sexual assault and the actions taken regarding those reports, interviews with victims of the reported sexual assaults, which included both unrestricted and restricted reports, review of Alaska National Guard sexual assault policies, practices, training, and command emphasis, and review of the results of the statewide command climate survey, specifically the responses to the questions on the survey regarding sexual assault. And so I listed the findings of the OCI team. And do you want me to go down through the list, or?
I think that you don't have to go through them line by line.
Okay.
We do have this. This is, I wanted you to present, a general overview of the work that you did, especially for folks who are listening in who do not have access to this document at this time.
Sure.
It is publicly available on our website for folks who want to look at it. But I also just want to have this in the record. So thank you very much.
Oh, you're welcome. So I also listed the recommendations of the assessment team based on their findings.
I think that the maybe last 4 bullet points of what was recommended, you might want to say aloud, please.
Sure. So they recommended to reinforce leadership education on the SAPR program and investigative resources available to the command. Set the tone for sexual assault and harassment awareness by strengthening the policies that are meant to educate soldiers and airmen about respect and responsibility for one another. The Alaska SARC needs to reinforce training on reporting options with special emphasis on who can take a restricted report. And all allegations of misconduct under investigation by local law enforcement be tracked by the Office of the Staff Judge Advocate or a law enforcement liaison, such as a provost marshal officer. Additionally, when appropriate, the staff judge advocate should make recommendations for administrative action pending the finding of local law enforcement officials, to include removal from the AGR program.
Thank you.
And so after that investigation, a year later in 2015, the Attorney General retained retired Alaska State Court Judge Patricia Collins to review circumstances surrounding the handling of Alaska National Guard sexual abuse and harassment allegations reported by some service members between the years of 2010 and 2014. And that investigation had called for a written report of findings, including the nature of each allegation investigated, whether the allegation was subject to the DoD's restrictive reporting system, whether the known allegation was adequately investigated by state or local law enforcement, and if any improprieties occurred, whether reports by local or state law enforcement were forwarded to state or local prosecutors, and whether the reports included a recommendation on prosecution, whether appropriate action was taken by the assigned prosecutors, whether the contents of an investigation by state or local law enforcement was communicated to executive branch employees, and if so, whether appropriate action was taken. An opinion on whether any of these cases would require further investigation and recommendations for handling such matters in the future. And some of the findings of Judge Collins' report were that members of the Guard were not reporting sexual assaults to the SARCs because they did not trust their command to help them. Instead, they were reporting to the chaplains and others. And let's see. The Alaska National Guard's military code prevented the Guard from prosecuting military offenses such as sexual assault. And as a result, Guard members who violated the existing code were only subject to administrative penalties, and they could not be fined, imprisoned, or dishonorably discharged. She also found that there were 16 sexual assault reports made to Guard officials between 2010 and 2014. In 10 of those, members were identified as the alleged perpetrators. Most, but not all of the cases were properly investigated by law enforcement. And additionally, some cases resulted in personnel actions, up to and including other than honorable discharges. And the report made several recommendations. Supervisory personnel should listen to the chaplains, protect victim confidentiality, and promote expanded victims' rights. Maintain a summary of all climate survey and sensing data on leadership and report to the governor.
And there's, I don't mean to interrupt you.
Go ahead.
No, the middle piece is also important to talk about. It says acknowledge and apologize for past
mistakes. Yes.
and expand state resources for silent victims. You may proceed.
Sure. So in 2020, the governor directed Alaska's Department of Administration Oversight and Review Unit to conduct a statewide assessment to ensure the state was properly addressing any allegations of sexual assault, sexual harassment, or retaliation occurring in the Department of Military and Veteran Affairs. And the DOA ONR conducted the review with the assistance of the Alaska National Guard. And the objectives of this review were to identify the improvements had been made following issues related to sexual harassment and assault identified between 2010 and 2014, and also to assess instances of misconduct allegations and evaluate how incidents were handled by the command in the past and how they would be handled if they occurred presently. And the review also sought to determine if corrective recommendations made previously were implemented by the Alaska National Guard, and if so, what current effect implementation had on the Guard's organizational climate. And the ONR review found that the Alaska National Guard had fully addressed and implemented the recommendations made by Judge Collins and the OCI regarding equal opportunity, sexual harassment, discrimination, and retaliation issues. And the Guard Command adequately and appropriately responds to allegations of sexual assault or harassment by Guard members. So those were some of the findings. So overall, they found improvement and that the Guard had addressed all of the deficiencies cited previously. So they also made several recommendations to require advanced sexual harassment, assault prevention and response program training for leadership, increase efforts to educate Guard members on sexual assault reporting knowledge, establish an official channel of information sharing with civil authorities, because there was not anything, no memorandums of understanding or anything permanent with set in stone with the civil authorities. And also to continue to work with the National Guard Bureau to retain a full-time military judge. And so now I'll talk about the information that I found regarding the state of Wisconsin. So in 2019, the governor and US Senator Tammy Baldwin requested assistance from the OCI to provide a detailed assessment of the Wisconsin National Guard's sexual assault and harassment reporting procedures, investigation protocols, and accountability measures. And specifically, they requested that the assessment team review allegations made by service members, review allegations related to hostile work environments, examine the Guard's coordination with local law enforcement, examine the Guard's use of command-directed investigations for allegations of sexual assault, conduct a statewide survey of the Guard's culture and climate regarding sexual assault and sexual harassment, including on-site interviews with all major subordinate commands, and assess the Guard's adherence to an implementation of DoD and NGB policies and procedures under the SAPR program. So similarly to Alaska, the assessment team developed an action plan, which included, again, a statewide command climate survey, collection and analysis of relevant documents, on-site interviews of complainants and subject matter experts, and site assessments, visits, and canvassing of Guard service members. And the team made 22 separate findings and 21 recommendations in the areas of SAPR program implementation and management, sexual assault investigations, sexual harassment and equal opportunity program implementation, accountability through administrative and disciplinary actions, and command climate. And overall, the team found that the Guard's programs and systems for handling allegations of sexual assault, sexual harassment, or other workplace or service-related misconduct were non-compliant with federal law and regulation, and in various respects deficient or failing. And the OCI team made 3 overall recommendations. to update or correct all written policy and procedures, protocols, and practices to conform with federal law, regulation, and policy, request an NGB staff assistant visit to facilitate program, system, and relationship updates, corrections, and improvements, and reinforce program management tools, processes, and services through more deliberate communication and coordination with internal, external, and higher echelon partners and resources. So following the release of this report, the governor issued an executive order requiring the Guard to develop a corrective action plan, which would be approved by the governor. And in February 2020, the Guard submitted the corrective action plan, which was approved by the governor. And I have hyperlinks to those documents if committee members and other people wish to see them.
Thank you.
And so more recently, on February 14th of this year, the governor announced that the OCI had officially closed out its assessment of the Wisconsin National Guard's sexual assault prevention and response program. And the other review that Wisconsin conducted was a Department of Justice review. So in 2021, the Wisconsin DOJ conducted a review of more than 30 sexual assault cases that were previously investigated by the Wisconsin National Guard between 2009 and 2019. And each case was reviewed for an assessment of whether further investigation was needed and whether the cases should be referred to a district attorney. So the review did not result in any new criminal charges, but they made several observations regarding the cases it reviewed, such as fraternization and alcohol, because some of the cases involve complaints of and investigations into fraternization between National Guard members of different grades or ranks. And many of the cases involve the consumption of alcohol by the alleged offenders. And the DOJ found that this was not this was in violation of Army regulations, but also found that the Army regulations were unclear in terms of defining prohibited relationships. I'll see another finding with investigations. Some of the cases reviewed by DOJ involved investigative measures taken by the Wisconsin National Guard that were not conducted in a trauma-informed manner. And at least one case investigated, disciplinary investigations were unacceptably intertwined with sexual assault investigations. And then another finding, in some cases, there was a failure to keep survivors well informed of the status of their report. So they recommended to ensure continuity of advocacy and representation, to the extent possible, the Special Victims Council program should assign the same SVC to a survivor until the case is closed. And the survivor and their SVC should be kept apprised of the status of the investigation, and survivors should have the opportunity to ask questions and offer input for consideration. And the final state, Vermont, they had an OCI review in 2019. The Adjutant General requested assistance to provide a detailed assessment of the Vermont Guard's command climate and systems with the end state of improving the Vermont National Guard and ensure that the governor's and the Adjutant General's priorities are being implemented. Specifically, the Adjutant General requested a review and assessment for the past 3 years of any system or process issues with adjudication of misconduct within the Vermont National Guard and the punishment that resulted, and review and assess any system or process issues with investigation of misconduct performed by the Vermont National Guard consistent with policy and regulation. Review and assess incidents of discrimination or sexual harassment or violations of EO policy within the Vermont National Guard and any action that assaulted. Review and assess incidents of hazing, bullying, maltreatment of subordinates within the Vermont National Guard and action that resulted. review and assess the efficacy of the selection, promotion, and placement policies within the Vermont National Guard for both officer enlisted AGR technician and Title V positions, and conduct a statewide survey of the Vermont National Guard's culture and climate, including on-site interviews with all major subordinate commands, and assess the Vermont National Guard's adherence and implementation of DoD and NGB policies and procedures under the EEO, EO, and Sexual Assault Prevention and Response Program. So again, the assessment team developed an action plan for the investigation, which again included a statewide command climate survey, collection and analysis of relevant documents, on-site interviews, and site assessment visits and canvassing of Guard service members. And here are the findings that I listed of the OCI assessment team in result to their sexual assault and sexual harassment prevention and response. They found that the written policies were generally consistent with federal law, but they lack specifics to ensure compliance within the major commands of the Vermont National Guard. Historically, the Vermont National Guard Sexual Assault Prevention and Response Program failed to properly report and track sexual assault allegations and case data, but has improved since 2017 to the present time. They also found that the Vermont National Guard does not maintain any MOUs or agreements with community-based resources to enhance prevention or response efforts.
And then the last thing on the page there.
Yes. The last bullet?
Yeah.
Okay, the Vermont National Guard historically conducted unauthorized command level investigations into alleged sexual assaults, but has improved since for the period of this assessment, 2017 to 2020, and has properly referred unrestricted reports to appropriate investigatory entities.
Thank you.
And then they made several recommendations. Are there any in particular that you would like me to?
Scroll down to the bottom, please.
Okay.
I just think that the last bullet point.
Sure. Historically, the Vermont National Guard, in particular the Air National Guard, the Army the Air National Guard, investigated sexual assault allegations incorrectly via command-directed investigations, although there has been significant improvement since 2017 with referral of sexual assault matters to military criminal investigative organizations, civilian law enforcement, or OCI for investigation.
Thank you.
And then I listed a couple of additional resources. Both of these are the Chief National Guard Bureau's policies and procedures for complex administrative investigations.
Thank you very much for summarizing the research of the 3 other states. We can see, the committee can see, the public can see that there have been overlapping investigations in all 3 states, some initiated by AGs, some initiated by their adjutant generals, some initiated by their governors. Are there any questions from the committee about any of the research that Kristen Braun has presented to us? I will also ask if the Adjutant General has any questions or comments about what has been presented from this research of other states. The chair recognizes Representative Supika.
I don't have a question. I just wanted to thank Ms. Braun very much for this, and I haven't had a chance to dive into it as deeply, but I will, and it's really helpful. So I just wanted to give you some thanks.
Oh, thank you.
Any other comments or questions? Adjutant General, you may proceed.
Good. Thanks, Senator. The only thing I would add is that one of the things that we've done as I read through those recommendations, I have my team, as you've met some of them over the different meetings, but that changed, or we don't do that anymore. I mean, you just got to remember that a lot of the changes that have occurred in the program, and you heard Kartika Wright the other day saying just keeping up with the changes has been difficult. a lot of the changes that we've had in the program have come as a direct result of these investigations. Many of those recommendations have been incorporated into everyday work now. As a matter of fact, I had pulled out, when this research had come down, I had pulled out an email that I remembered back in January of 20, where we had sent the Wisconsin report to our IG and said, hey, can you look at this report, compare it to what we're doing, and come back with any kind of recommendations, or are we missing the boat on anything? And again, she came back with a couple things. Hey, we could probably tweak this and tweak that, because, so we just like an aircraft accident, when you do an after action and you try to make sure it doesn't happen again, we look at all these reports and try to make sure that it's not a blind spot in our own programs. So that's how we use them. Thanks.
Thank you, General Farnham. Are there any other questions or comments from Ms. Braun? Seeing none, again, thank you very much for providing this research for us. We are not in a position to have to necessarily recreate any wheels, because this is being done, and we know that improvements can always be made. So thank you again for providing the committee and the public with your research.
You're welcome, my pleasure.
Thank you. General Farnham, as long as we're on the issue, we have seen that you have requested independent review from OCI. They have responded with a yes. Can you just give us an idea about the process going forward? Timing and all of that.
So I talked to General Little, so there's not any confusion. OCI, General Walker is who I put the request in with. And that's kind of the bulk of the investigative part, but they all fall under the umbrella of the Chief of Staff of the National Guard Bureau, and so that's why the response is from General Wills, GG Wills, saying, hey, that they're going to do it, because it takes more than just the OCI expertise to do these things, and a lot of that falls under personnel, and that's why the Director of Personnel is involved, General Little, because when you start talking equal opportunity, some of the harassment issues and some of the policies on separations and all that stuff, it's under personnel as much as it's under anybody else. So, right as of yesterday, when I talked to him, there's a couple of, he's basically said, let us know. We've had a meeting with the team, who identified who would be on the team, and said, just say the word when you think it's most appropriate for us to mobilize and get started. So again, it's something that they have, they're committed to do. They're glad to do, and ready, ready to go. One of the things that the conversation ends up being, when is the right timing to do something like that, as you kind of meld that in with all the changes that are coming. And I think I've mentioned to a couple of folks, the 5 additional folks that are coming in prevention. I think there's going to be an announcement in the next couple of weeks, official announcement, that we may get a few of those 27 states may get some of that help a little bit early because of some of the things that have happened in the budget, now that there actually is a budget. So there's some changes that are coming sooner. Other changes are going. So where do you slide in any kind of an assessment to take the most advantage of knowledge of what those changes are? But that's something that can be discussed further on. But I mean, as you know, there was a stay or a moratorium or whatever on doing these investigations and inspections and assessments, or whatever we're calling them, because they were falling behind on their actual investigations on the cases. And so I was pleased that they were willing to help out, because I think it's a good thing.
Thank you, General. Are there any other questions for the General about the OCI investigation request, assessment review? Great. And there may be, the chair recognizes Representative Riley.
Thank you, Mr. Chair. General, I do have a question for you. When the OCI report is ready, how is it going to be shared? And I just want to make sure that's going to be shared with the AG, the Advisory Council, and the legislature. Oh, I think you might be on mute.
Yeah, you'd think we'd have that figured out by now, I know. I think it says in the letter that they would share it with us. In the email that I got before the actual letter, I got an email and I just asked if could they put it on letterhead, just so, because I knew everybody would want to see it. But in the email said they would share it with the governor and with me. So, and then I see no reason why we can't share it. It'll be public knowledge, at some point after that. But I guess the governor and I would get it first. But as you found, the Wisconsin and those all end up public anyway. And again, that's the way we do business in the Guard, in the sense that we all learn from these. We'd seen all these reports that were presented, and that's how the Guard does it. You read other people's reports and try to improve yourself.
And so, General, you wouldn't have any objection to sharing that report with the committee when you receive it, or sometime shortly thereafter? You're on mute again.
Absolutely not. I think that would be,
excellent.
Not an issue with that.
Thank you. So we will move back to the bill analysis on page 4. Janet, you're on again, if you don't mind. And I would request, since the bill was drafted before the executive order was signed, I would ask you to walk through the Advisory Council on Military Sexual Trauma on your second column. I know you have 2 columns that compare what's in the committee's bill proposal, but instead of going through both, just let's talk about what's in the executive order, and we'll go from there. Thank you.
Certainly. So the executive order is available on the governor's website, and it is linked to this bill analysis online as well. And the governor's executive order has a 10-member advisory council with a DVM commissioner, as well as the Department of Public Safety commissioner, attorney general or designee, president of the Maine Prosecutors Association. I think Dave Maloney referred to that earlier, and as well as the president of the Sheriff's Association, the chair of the Maine Commission on Domestic and Sexual Abuse. That's the commission we talked about earlier today. The executive director of basically MICASA, but you can't say it that way when you write these things. An advocate for survivors or a survivor of military sexual trauma who participated in the military justice or the state court system, as well as a representative of an organization that works with survivors of military sexual trauma. All of these, there's no term given for the membership, and it is written as a permanent advisory council, but they do serve at the pleasure of the governor. So if the governor needed to replace them, the governor could, or if they needed to leave, then they could be replaced. It specifies there's no compensation, which I only pointed out because I guessed what you wanted and put expenses only in the bill. So just so you know that there are different options for that. Yeah. And there is a whole host of required duties, including identifying best practices and reporting and preventing sexual trauma in the Maine National Guard. That's similar to a duty you have. Identifying barriers to reporting sexual trauma in the Guard, as well as state resources available to respond to and prevent sexual trauma in the Guard. They're supposed to examine improving communication between the Guard, state, county, and local law enforcement, as well as prosecutors for investigation and prosecution of criminal acts that occur between members of the Guard. They're also supposed to examine ensuring that relevant violations of the Military Code of Justice are communicated to Maine authorities. Item 6 of the duties is to propose an amendment to the criminal harassment statute that we discussed earlier. There is an amendment in the bill, but I suppose if both were to go forward and they thought the way it was written wasn't good, they could propose how to revise it. They would also identify resources within the state to support survivors and to make sure those resources are promptly provided to members of the National Guard. Identifying a process to ensure survivors have an opportunity to communicate the problems they've experienced during the reporting and investigation process, and ensure that their input is incorporated into any policy changes or actions made by the Guard. Number 9 is to improve the communication between survivors state prosecutors, and state, county, and local law enforcement, to identify the ways that the department can increase its involvement in the state's response to sexual trauma in order to better inform its internal policies, as well as identifying federal policies and resources that are available to support the efforts to respond to and prevent sexual trauma in the National Guard. And then finally, to make recommendations to the governor as appropriate to enhance the prevention, reporting, and timely prosecution of sexual assault and sexual harassment within the Maine National Guard. And although it's written as a permanent ongoing advisory council, there is a specific reporting deadline of December 1st, 2022. That would go to the governor. And then after that report, there's indication that they would continue to meet, but there's no specific further reporting date, although obviously they could submit further reports if they're ongoing and meeting continuously. So that's the structure of the executive order. I have thought about some things that were raised at the public hearing and at the first work session about the existence of that executive order. And I did want to say that you could not, as a legislature, to direct that advisory council that the governor made to do things, because that the governor's office advisory council, that's sort of a separation of the branches issue. But there's nothing preventing you from making a different advisory council that looks very similar, has very similar members. And in that way, you could sort of tweak some of the duties, make sure additional duties are included. And then it would be up to the governor whether to have the same advisory council do both duties or to have two parallel advisory councils, because she's in charge of the one that's created by executive order. Alternatively, you could have unallocated language if you wanted additional duties to be considered. You know, could say, consider having these, or write a letter. So there's a lot of different approaches you can make. It just depends on what you want to do moving forward. But there isn't anything preventing both advisory councils from moving forward. It's just a matter of figuring out exactly what you want to have happen. Is it sufficient the way it's written? Do you want to have more duties, different people involved? So there are a host of different considerations, but it is really important that you not direct the advisory council made by executive order to do things, because it's not the legislature's domain.
Yes, thank you, Janet, for that. Separation of powers is very important, and our Constitution makes it about as clear as any Constitution that one branch of government cannot do the functions of the other. Are there any questions or comments about everything that Janet has raised regarding both of the advisory councils that are proposed in statute and that have already been established by executive order? And you may stop sharing your screen to see how much of this discussion we will have. Any members of the committee want to weigh in on how to move forward with the section of the bill that creates a different advisory council?
I did forget to say, sorry, that this bill, as you know, was put together quickly. So it's not a very detailed paragraph structure of exactly how the advisory council would work. That could be made more detailed to look more similar to some of the other statutes. And I did check internally. You can set it up with a list of the governor appoints. You would be able to independently decide, do you want confirmation or not of these members? It doesn't have to be automatic. You can work out all of those details, and we can make it as formal looking as possible. I did just want to say that that was written quickly, which is why it looks very informal. It can be gussied up, as you will.
Thank you, Janet. Appreciate the hard work, the expeditious work everyone has done on getting this bill turned around in a very timely manner. Any questions, comments, or discussion about this part of the bill and how it interfaces with the Executive Order Advisory Council? I did hear Janet say something around perhaps while we can't direct any work of this Executive Order Council, we could certainly write unallocated language to suggest some other considerations for it that could be considered by the executive branch. Or we could have a parallel advisory council. What does the committee think? We can certainly think about it and come back and talk, but these are the options that we have in front of us. And since everyone is silent, and it's 1:15. We will just move on through the bill analysis. So let's go to the annual report section. And then we will go to the part A of the analysis and invite in the Office of the Attorney General, and then we can talk about all the other additional considerations and whatnot. So that's what we'll do.
So section B11 of the bill has an annual report from the Adjutant General with several different provisions. And this report is supposed to be prepared in consultation with the statewide coalition against sexual assault that is part of the cooperative agreement, which is in a different part of the bill. And so this annual report would come to this committee or the successor committee by February 15th each year, including data on reported incidents of sexual assault and sexual harassment within the National Guard in each of the preceding 10 years, including the outcomes of any civilian or military proceedings related to those reports, as long as that data and information can be shared under federal and state law without revealing the identity of any victim. Also requires the report to include a description of the previous year's sexual assault and sexual harassment prevention trainings in the National Guard, a description of the current practices and procedures for preventing and investigating sexual assault and sexual harassment in the Guard, and a summary of the previous year's activities of the Advisory Council on Sexual Trauma in the Maine National Guard. And if you remember, I mentioned this a little bit before, Representative Riley proposed amending the bill to eliminate the requirement that the Adjutant General summarize the Advisory Council's activities, because actually I didn't mention this before, it's just written. We didn't go over what's in the bill, but Representative Riley's proposed amendment to the bill would make the Advisory Council entirely a creature created by the governor. And although input could be sought by the Adjutant General, it wouldn't be directed by statute. So therefore, instead of having the Adjutant General provide information to the committee about the council, it would provide its own report directly to the committee. And so some of that cleanup language is also here in this annual report section. It also adds a requirement that the Adjutant General include in the annual report information from the Maine Coalition Against Sexual Assault on their recommendations about the prevention of and response to sexual assault and sexual harassment within the Maine National Guard. Again, there were concerns about sharing of the data, and I believe General Farnham has expressed the real desire not to give up victim privacy, because they do promise certain privacy to victims and they don't want to violate that in submitting this report. And then also Pratika Wright, who was a SARC in the past, suggested that as little ancillary information as possible be included when all of this information is shared with the committee to prevent people from being identifiable given the small size of the Maine National Guard. So again, a lot of privacy concerns raised about this provision.
Thank you. Are there any questions or comments from the committee on this provision of the bill? You can stop sharing your screen, please, and thank you. General Farnham, do you have anything to say about this section of the bill, since the committee is silent? So.
Senator, just again, reiterating the privacy piece, and in the text it says, it talks about federal and state law, and it's not just state law and federal law, but we have the federal regulations that we have to live by as well, not just the laws. And then there are pieces of it, as I kind of alluded to before, that are in that gray area that are a judgment call by our professionals as far as what what they feel comfortable releasing and talking about. And some of that, just to give you a little taste of it, I had sent some data to you, I think it was last weekend or whatever, and you would be shocked at the amount of discussion that went around with those professionals as far as how we combined senior enlisted versus junior, and if we did it this way, then that would only leave one person in that category, and somebody might be able to, so there's a lot of it is just a nuanced judgment of how we present the data to make sure that you get the right picture, but at the same time not expose the ones and the twos and the that to the layman, I look at it, I say, is that just a one on a, how does that mean anything? But you know, if you're that one person and you see the one on a table somewhere and you know it's you, that's the part that we are concerned about. But anyway, that's all. Other than that, I don't have an issue.
Thank you. And is there a way to allow for the information of the survivors to come forward, not in confidence? Or are you required by law, rule, or regulation to disallow for that regardless of the will of the survivor?
I think as was said earlier, I mean, the individual victims can talk about and say what they want. We are just, our hands are tied more on us releasing privacy, or confidential information. And again, that's not just from that side, but we have the same things on the employer side when what we do for administrative action, and where we get sometimes critiqued for not doing anything. Well, a lot of that is because I can't put up a sign that says, you know, Joe Smith this happened to him. I just, it's confidential information that I can't, that person can go tell anybody what happened to him, but I can't do it.
So the information that you have provided to the committee on this issue, would that be something then that could be provided to the committee every year?
Everything that we've given you so far, we haven't given you anything that we can't. So anything that, anything that you have now is the type of information that we're comfortable with. And we are continually working on, what other types of information can we share to give you a better picture? Because I am confident that there is an issue, there's a problem. I think I saw in one of the reports that the recommendation was to apologize and move forward. That's powerful stuff. I mean, we admit there have been problems in the past, and there continue to be issues in the DoD, in the National Guard, and in the Maine National Guard. But as we move forward, we want to be able to show that progress, and we want to be able to share that information. So, I have no issue with that as we go forward.
Thank you, General. So Jen and I would say that if we were to include this provision in the bill, that we would just make it clear that what we would be asking for is is an annual report based upon the information that we've received this year as a part of this process. And I don't know exactly how to write that, but that would be, I think, that would address all the concerns that are here, because if they've given it to us already, we'd be asking for a similar packet of information annually hereafter. So I would say that if this were to be included in the amendment that we will vote on later, that's how we would try to word it. And I'm gonna put Representative Riley on the spot and say, would that be something that you would support if we go forward with adding this to the bill, or keeping this in the bill as amended?
I would be okay with that. We can, yeah.
Okay, great. So with that, I will now invite the Office of the Attorney General, the Attorney General himself, to come to talk to us about independent review. And I will first invite Attorney General Fryan, and he can tell me who else he'd like to have involved in our conversation. We're going back to part A, and it's part A, but it's also a question on page 7. Welcome, Attorney General Frye. Please introduce yourself.
Yes, thank you. Good afternoon. My name is Aaron Fry, and I have the privilege of serving as Maine's Attorney General.
Thank you for being here today. We are asking you if you would be able to conduct an independent review contemplated in this proposal by Representative Riley and the committee, and what your office has done or is privy to regarding any criminal convictions of sexual violence that have occurred between members of the Maine National Guard in this state or in any other.
Yes, thank you. So working perhaps backwards on those questions, we did some looking in the time that we were given to assess whether or not we could identify specific cases where members of the National Guard may have been convicted criminally. I would point out earlier, you had probably a more appropriate subject matter expert in District Attorney Maloney. These types of cases are going to be generally prosecuted at the district attorney level, at the prosecutorial district level, because even though the Attorney General's office has concurrent criminal jurisdiction with DAs, usually the primary criminal conduct that we prosecute is going to be related to homicide, right, or to crimes involving public officials, or certain types of, I'll call them white collar crimes for lack of a better term. So I say that because in my office, we don't have those types of convictions. Our research really only turned up a couple of cases of note that got some attention. One was involved a National Guard member. I think this was back in 2021. It occurred out of state in the state of Arizona near the border, and it was it was at least a Maine Guard member. It references a second colleague, but we didn't dig into who that may have been, if they're from Maine, if they're from someplace else. And then a second, it just involved a Guard member who may have committed some other crime. And so we could connect. They had their status as a Guard member, but it wasn't related to the conduct that I think this committee is dealing with LD 2029. So I just offer that because we certainly don't have any records that we could look to that would demonstrate convictions for this conduct, because we're not the primary office that prosecutes that. And we hadn't been called in on a conflicts level, right? If maybe a DA's office couldn't do it, they might ask the AG's office to take it over. Just didn't have anything like that. Moving a little bit further in the answer to your question, Senator, this office does have the ability to prosecute crimes, all crimes that are set by the legislature. And we would be in a position working with, collaborating with the district attorney's offices to evaluate, assess the vibrancy of how different complaints of criminal conduct are received, are processed, how they may have been processed. Looking at whether or not there is conduct that should be prosecuted that is not being prosecuted, why that is, and how that can be addressed. We are in a position to assist in that effort, or to help with that effort. And again, that's something that we have an investigations division. They can work with local law enforcement agencies. It frequently does work with local law enforcement agencies to evaluate different criminal conduct. And again, with the prosecutors, with the elected DAs, we have a very solid working relationship and can figure out how to ensure that all of our seals are strong and how this conduct is reported in, addressed, investigated, and where appropriate, fully prosecuted to the fullest extent of the law. Getting to what I think is the end of that question, it's a little bit more challenging on a type of investigation that would involve, say, culture of an agency, or looking at how the Guard is acting, what their policies are, and that's largely because this office does not typically engage in a agency-wide investigation in culture. Not to say that we can't quarterback it, not to say we can't work with appropriate consultants. An example of that, by the way, is probably what you saw with Alaska, where Alaska brought in the former justice of their Supreme Court to do the evaluation. I mean, that would be what we would do. I think what I'd offer, though, is that to the extent that we already have a commitment from the Office of Complex Investigations to do its look at this, we have the Advisory Council on Military Sexual Trauma that the governor has ordered by executive order, that includes my office, includes other very relevant voices in this discussion. That's going to be an overlay, I think, consistent with what we've seen, particularly in states like Wisconsin and in Vermont that were reviewed earlier, is that the opportunity for OCI to be engaged before the Attorney General may get involved. I just offer that we're probably going to learn some very valuable insight from the OCI report, from this office's connection with the advisory council that the governor has set up, that may allow us to be more constructive once we have some of that information in. So I hope it was a long answer. I apologize for that. I think it was responsive though to that question of sort of how we might be involved and maybe where it might be premature for the office to be involved and just what we don't have for information.
Yes, thank you, Attorney General Fry. I did look back. So in Alaska and in Wisconsin, there was an overlap with those reviews because they were separate. So for instance, the Alaska Attorney General started in 2015 to look at how allegations were reported and handled between 10 and 14. And the OCI assessment was promulgated in 2014. And so they did overlap to some degree because they were looking at different things, which is exactly what you said at the outset. You wouldn't be able to get involved with trying to do any internal investigations of the Maine National Guard. It would be more about how are we dealing with unrestricted reports, criminal investigations, and the cooperation between civilian law enforcement and whatever is going on with the National Guard. So are there any questions or concerns from the committee for the Attorney General to address while he is here? Chair recognizes Senator Farron.
Thank you, Mr. Chair. Thank you, Attorney General. Hey, you don't come in front of us very often, so we got to ask you a question, right? You started when you answered Senator Hickman's question about the cooperation and the communication between your office and the Attorney General, and the district attorneys, right? And looking at whether appropriate pieces are being followed through. That happens now, right? I mean, we don't, I guess my understanding is you already have that relationship with the DAs across the board, and that this legislation or what we're talking about here isn't something new. It's how you already operate with the DAs. Am I correct in that assessment?
Yeah, so first, I appreciate being before you, Senator. I regret that I'm not before you more often. Or maybe I don't. I guess it depends on the questions. But more seriously, yes. So that relationship is established. I think the extent to which this very specific evaluation, sort of looking back to make sure that we are firing on all cylinders in how making sure that investigations are coming in the way they're supposed to, that we're having the right conversations with law enforcement agencies. It's really just, even though we do this on a regular basis, it's not establishing anything that isn't already there. We do work well together. I think it's just about having that sort of look back and double check that I understand is of interest to the committee. But you're right. I mean, this is a relationship that is longstanding, and we have very solid relationships that flow both ways, right? Yeah.
Any other questions? Chair recognizes Representative McCray.
Thank you, Mr. Chair. Thank you, AG Fry, for being here. And yeah, we should see you more often. I think Senator Hickman summarized what I was thinking I was hearing well, and you confirmed that. And I think we had, out of the discussions, testimony that we've had, it seems like this is, as you put it, narrowing in on the specific issue, not that it's a new relationship, but specific to the issue. And I guess a question for you and the committee is, if we do this as part of the bill, we would also be asking you to get back to us, and perhaps out of that, there might be indications that there's something else we need to be doing. Would that be a fair prediction of what might happen?
So I believe so. You know, much like we saw with Wisconsin, right? And I suppose this would be my aspiration for what we see and what's being contemplated in direction from this committee is what we can clearly do in terms of the analysis of whether or not there's criminal conduct. We're going to be looking at what reports have come in, what investigations have turned up, further investigation, what it turns up. It may very well be that just like in Wisconsin, there may not end up being anything that we can prosecute beyond a reasonable doubt, right? But there is going to be that ancillary information, the concentric circle of information that will allow recommendations to be made about, you know, what we learn about how reporting was occurring, what we learned about how investigators were doing the job that they were charged with doing, how it is that the prosecutorial offices manage that information. So I do think that while there is and I hope that this is responsive, Representative, to what you're asking, you know, while there is going to be this specific focus, I think getting that additional information that just sort of is a byproduct of the criminal investigation, it's going to confirm our processes. We're going to report that back. We're going to learn stuff that we didn't know before. We're going to report that back. We're going to be available to talk about that as best we can, consistent with you know, what's in the interest of the survivors and, you know, and what we have to protect. But I also think that, and this is just an example of the advisory council that the governor set up with the AG's office on that. This is also an opportunity for the AG's office to be learning, to be engaged in a conversation that, again, we're going to overlay with the work that, you know, the double checking that we're doing on the criminal investigation side. I do think that will provide valuable information to report back on, to communicate with General Farnham, right, with his team, to communicate with the governor's office, to communicate with individual legislators as this develops, to communicate with survivors, to make sure that we can increase confidence that their voices are being heard here. So I think that there is going to be stuff to report back. I certainly can commit, for as long as I have the privilege of holding the position, to be willing to report back as the committee needs to make decisions about how to proceed.
Thank you. And a follow-up, Mr. Chair?
You may proceed.
Thank you. That was really helpful because I think you articulated what certainly I feel that this is a process that is something everybody wants to be and needs to be involved in. It's not pointing fingers or it's to try to make it the best system possible. And by all hands on deck, I think that's a Navy term, isn't it, Senator? I think that would get the best result. So just thanks for that.
So thank you. Janet, can you please put up the research that we just saw earlier? And I feel like the Attorney General was almost quoting from it, and I just want to see, asking a question about it. So on page 2 of the research, when it comes up, if you scroll to the middle of the page right there, and just, so Attorney General Fry, it almost sounds like what you said before Representative McBride asked her question was what Alaska did when it looked at 1, 2, 3, 4, 5, 6, and 8. I mean, 2 is obviously very specific to Alaska, but if we were in this bill to write unallocated language to direct your office to do, say, 1, 3, 4, 5, 6, 7, and 8 with a report back to the committee about what you found out about these things, is that what you were talking about? Perhaps something like that, maybe?
Well, it would, so I without the benefit of fully absorbing those individual points, it is along the lines of being able to provide information for the committee about what we learn, confirming, you know, how this information has come in, how it's been handled, whether or not there were missed opportunities or not when it came to managing these cases, specifically with respect to criminal, right? And then And then to the extent that there may be additional information that, we just, because of how it came in, we gleaned information about some other process. We might be able to comment on that, although it's not something that I could anticipate that we directly look for. So again, without having, I did print it off. I was following along with the analyst on this. I hesitate to commit specifically to those numbers, other than to say, I do anticipate the information would look something like that, because the idea is to provide confidence in how it is that criminal investigations are being performed and completed into this conduct specifically.
Great. Janet, did you hear all of that? Thank you. You can stop sharing your screen, please. The chair recognizes Senator Farron.
Thank you, Mr. Chair. Mr. Attorney General, if that type of language makes it into the bill, I'm assuming, that it said specifically in there that they retain the services, that you would be looking at hiring someone from outside. And I imagine there'd be some staff with this to go through that. Would you anticipate that you'd have some kind of a fiscal note to be able to accomplish that piece?
With respect to the work with the DAs and the investigation division, I am not anticipating that is something that we're going to need additional resources to do. The more detailed or the more extensive the reporting requirement becomes, the greater challenge it's going to be to really dig in and report on that. So I guess that's the non-answer.
No, until we define it, understand.
Yeah, I mean, the more specific that the committee gets and the greater the expectations, I think I will worry about the extent to which we're going to be able to fully report. And again, I think this is also recognizing that we are going to have, Alaska had OCI working at the same time as well, but we are also going to have some strong input from the advisory council, I hope, right? I mean, that's the objective. That is also going to provide some information. So that's the long way of saying, the more detailed and the more extensive the language gets, the harder it will be to absorb that. So,
thank you.
And I just want to make it clear, I was pointing out the general scope of the review, not necessarily retaining a retired judge or any other staff to do that really detailed stuff. I think that what Attorney General Fry said, and I said, Janet, are you hearing this, is really what we're talking about. It's what he's already offering to do as maybe the third leg of the stool of the work he's already doing, but to focus on this in particular, serving on the advisory council. And then whatever work we see from the OCI, when that's finally reported back to us, we'll be able to give the committee all that it needs to provide proper oversight, because that is really our function, is to provide proper oversight, to try to get to the root causes and then the solutions to this problem that everyone has admitted is a problem that we are intended to solve. Are there any other questions for the Attorney General at this time? Just hang on, sir, just in case we do have some other questions that come up in the context of what I'm about to ask General Farm. So on page 7 of our bill analysis, General Farm, you have answered just about everything on here except for 2 very specific, or maybe more than 2, but 2 very specific requests that we wanted the committee to have an answer to, and anyone listening. And those were the differences in the definitions between restricted and unrestricted reports, the kinds of discharge, and we've already talked about confidentiality restrictions, benefits that may or may not be taken away from both the perpetrators and or victims or survivors. So I'll start with, please explain the definitions of and differences between restricted and unrestricted reports. And I see that the chair recognizes Senator Farron, who may have a question.
Yeah, I just, Mr. Chair, I just got a question. I think I'll ask Janet, maybe.
Yep.
I thought we had some of that in the work and some of the materials as far as the benefits and the, I just want to read it as we're going along. Some of those things you said, I think we received.
Yes, we received all of it, just about.
Oh, okay. I thought you said that that the general hadn't responded.
No, I just, because we have received the information, the general has responded. I wanted to just ask him to walk us through the responses that he's given the committee that we've seen, but no one else.
Misunderstood.
Yeah, no, he's
And I
definitely.
I was actually going to ask if you wanted me to share any of the screens. All of that stuff is posted in the electronic committee file, so I can find it quickly, but I defer to him entirely on how he wants to answer it. I'm just offering to help.
I think that if you could pull up the visual on restricted and unrestricted as like a PowerPoint, it will make it a lot easier for General Farnham to just walk us through it so we can all see it. And if we have any questions about any of the items that he has presented, then he is here to answer those questions.
Okay, Senator, thank you. That having the picture is much better. Looks like a military PowerPoint presentation. I'm comfortable with that.
Excellent. You may proceed.
Okay, Senator. So just the bottom line here, you can see when we start talking benefits and limitations that we get into the more specifics that we can answer any questions. And Tina Zaberik, who's been with me all along, has had a medical appointment today. She's been waiting for months for. So I've got a Bobby Joe Rogers, the Air Guards equivalent to Tina, is here today. She's probably the most experienced SARC that we have in the state, or have ever had in the state, because she did it in Hawaii before she came to Maine. And don't ask me why she moved from Hawaii to Maine, but I think that's good marketing for us. But just in real basic, historically, way back when a lot of these cases originated that you've heard about and get talked about, everything was kind of an unrestricted report, and the concern was that it prevented people from coming forward and reporting. So this restricted report was created, which allows the victim to come forward to their, through the chaplains, through healthcare professionals, or through the victim advocates and in the SOC program, and they can come forward and say, hey, there was a case, there was an event, and I need some of these benefits, these services. And so that's why restricted report was created, all with the idea of how can we best support victims. So again, you see on the screen, what comes along with each of those. Now that has been tweaked constantly since it was created. There was frustration in command. I think it came up the other day when there's a restricted report, I get a notice that there was a restricted report. And that's about all I get. I get that it was a military member. I may or may not know whether the perpetrator was a military person or not. I may or may not know that if it was, I think I know if it's less than 30 days or more than 30 days. Well, that more than 30 days can be 20 years ago, it can be 5 years ago, and I have no way of knowing. So, and that is, again, to protect the privacy and confidentiality of the victim. But it gets frustrating. The other part of it is that there are times that once you went unrestricted, there was no way, or said something, then you started to go down the unrestricted way, there was no way to get back into the unrestricted category. And that's something that's been changing just recently. And the way that you can start restricted, and then to say, after you become more comfortable with your victim advocate, and later on you might get the Special Victims Counsel, and as you get into the program a little bit more, the victim may feel more and more comfortable, and then decide to unrestrict it. Once it becomes unrestricted, that is when all the conversation starts with how we interact with the district attorney's offices and get into the local law enforcement and all that type of thing, only when it becomes unrestricted. So, that ends up being, important to recognize that the restricted thing is all about what the victim wants and getting them the care that they need as quickly as possible without them having to think through how much they want to talk or who they want to talk to, and making it easy as possible. Unrestricted, now it goes to, now we're full blown into local law enforcement and other investigating and that type of thing. And while we're talking maybe a little bit off that specific topic, but it was brought up in a couple of those other states in the investigation about improper command directed investigations. And I just want to make it clear, many years ago now, at least 7 or 8, 10 years ago, I think 2013-ish, they do not allow, I mean, once it's a sexual assault case, I cannot command direct an investigation. It immediately goes to local law enforcement, or if I don't have enough data to go to anything, then it immediately goes to OCI to do the investigation. We do not do sexual assault investigations as a command. They took that right away for a lot of the reasons that we've been talking about these last several sessions. So, I think hopefully that you can understand the difference between restricted and unrestricted report. If you get any questions, I can answer them, but did I answer?
Thank you, General Farnham. Excuse me, I had a coughing spell there. I had to turn off everything. I was going to check with the committee to see if they had any questions about this portion of the slide. Seeing none, please proceed.
Okay. What was the next? I'm sorry, I lost track of it.
Janet can put the slide back up. We're going to, I think we discussed everything on that first slide, limitations as well. And then the second slide says,
oh, okay.
There we are.
Again, this is more the details of the reporting. And again, this is part of the training that everybody gets. Commanders get it. Individuals get it, so that they hopefully know who to go to. And again, the message to any potential victim is, you've always got your SARCs, your victim advocates, and the behavioral health medical personnel, and the victim the victim coordinators, special victim counsels, victim advocates. I'm sorry, they can go to that, and that is the conversation. I think you also have a document that is a Department of Defense form that they step through as they help the individual make those decisions on restricted and unrestricted reporting, so that they understand. There were some questions the other day from Senator Marymount about how they get advised or whatever else, and that again, it's not left by chance. There's a form like everything else in the military that they step through as they advise this victim on which type of reporting they want to do. And then the unrestricted report, again, you'll see a lot of the, commander, investigator, JAGs. You can go anywhere to start the unrestricted report. There are, and then maybe that's on the other slide, there are a few kind of, as a commander, the old rule, and I think the current rule, although I think it's changing, is if a victim comes to you and says they were sexually assaulted, the restricted report historically had not been an option. It's kind of the what do you call this other? I just hear it recently when it comes to some of the child abuse things, whatever. There's these mandatory reporters, I guess is the term, and a commander is a mandatory reporter when it comes to some of these things. But as I've said, with everybody, the primary concern taking care of victims, that is something that is in the process of being changed. I'm getting a nod from my expert. It's already changed, where there is a way now for a commander to back off, immediately put a halt to things and not be forced to do the reporting. I still have to report it, but you can send it into the restricted lane at some point. So again, that is something that has been tweaked a little bit. Again, all trying to do what is best for the victim and what their needs are.
Thank you. Are there any questions about this slide from the committee? Chair recognizes Representative McQuaid.
Thank you, Mr. Chair. Thank you, General. I think you probably went through this before, but could you just tell me or have your staff person tell me the training a SARC has? Are they a clinical person?
I will turn that over to Bobby Joe. Thanks.
Afternoon. My name is Bobby Jo Rogers. I am the Sexual Assault Response Coordinator for the Maine Air National Guard. And I work hand in hand with Tina for the state program. So your
Welcome.
question, ma'am, was what is our training that we receive as SARCs?
I wondered, to be a SARC, are you required to have a clinical license of some kind, and at what level?
No, ma'am. So for the military program, the SARC position and all of the victim advocate positions are specifically non-clinical. So there is not necessarily a clinical background required. It's often preferred. And then there is consistent training that we, as what I like to call staff or professionals, go through. We have re-credentialing training that we have to go through to stay up with what's going on, not just in the DoD, but in the community as a whole. But we are non-clinical support. If clinical support is required, we refer out to whoever may be the best support option.
Thank you. And is part of the training to know when to refer?
Yes, absolutely. And so it's important to recognize that every step in this process is based on what the victim survivor wants. So we may be working with somebody, and in my mind, I can say, wow, this person could really benefit from some time with an LCSW. But if that client does not want to go see an LCSW, we cannot force them, and we don't force them. We're trying to empower them to take that control back. So we do get training on how to recognize that. Trauma-informed care is kind of our motto, right? But all with the effort to empower our victim survivors to take control of their recovery path.
Thank you.
Yes, ma'am.
Thank you. Are there any other questions on this topic before we move on to the final slide of this package? Thank you, Janet. General Farnham, you may proceed.
So, and this is just a continuation of what I kind of alluded to before about some changes and some changes of who can do a restricted report and how you get into that restricted report category. It's interesting that it's interesting that, again, a lot of this is focused on how do you get into the restricted and why do you have restricted. But if you notice in some of the data that I gave you before, the majority of our cases over the last 10 years start restricted, and then over time, as the comfort level improves, gradually become unrestricted. Now, how long it takes to go from restricted to unrestricted depends on it could be a matter of days and a week, or it could be a matter of months or maybe longer before they're willing to go from restricted to unrestricted. But again, that's all the call of the victim. But that category, vast majority start as restricted. And then in general, the majority of cases that are on that list there started restricted and went unrestricted over time.
Thank you, General. Are there any questions about that final slide? So one of the, thank you, Janet, you may take that screen down. One of the other things on here, we did receive the information about eligibility for benefits regarding how a person is discharged. And I think they're almost hard to read on the screen. I think if anyone wants to see them on the screen, we can certainly put one up. I think the one that we would put up would be the chart itself, not sort of the spreadsheet. So the chart, Janet, if you have it, has type of discharge required at the top, and on the left it says state benefit, and it's got check marks on it instead of the one with the table spreadsheet. It's just very difficult to read. And if you have that one that I'm talking about, it looks like this. If we could share that, it would be clearer to all to see what benefits are available to the general categories of discharge. And I think the committee's interest would be what benefits are available to other than honorable, bad conduct, or dishonorable discharge. But if we have it on the screen, the general can certainly take any questions about the different categories and
Sure,
benefits.
and I just throw out there while that's coming up, in general, looking at that, I think what you'll see is the difference that, once you get to other than honorable, once you get to other than honorable, there's not a big difference between other than honorable and when you get to the bad conduct discharge. If you want to go all the way to dishonorable, a lot of people like to throw around dishonorable discharges. Those only come through, like, you hear about them on active duty through UCMJ. It's got to be through the criminal action. The proof is just like in a criminal court, and the number of people, we throw the word dishonorable discharge around a lot. Very, very, very rarely, even on active duty, do dishonorable discharges get handed out. There are cases where you'll have people convicted on an active duty base and actually do time in the military prison, and they get an other than honorable discharge. So the two things are kind of separate, but I just want to point out that the differences there are some differences all the way to dishonorable, but those are very, very rare. But there is a pretty big jump when you start going honorable or general and you get to other than honorable, which is where most discharges are that are substantial, crimes or AWOLs without good explanation. There's a lot of things that end up in. Other than honorable is both is pretty darn significant outcome. So that does display it. The other document that you have is a little bit more specific on all the items, but as you can see, once you get to other than honorable, you've lost most of your, and that is all state benefits. So that's the ones you guys have control over, but you've lost almost everything with a other than honorable discharge.
Thank you, General.
And the federal benefits look fairly similar in just that general explanation of where the line is that you start paying the bigger price.
Thank you, General. Are there any questions from the committee about this chart? Chair recognizes Representative Supika.
Thank you, Senator. It's not so much to this chart. It's something general that you just said that I guess I was just wondering, and bear with me while I try to put it in a question that makes sense. Are there instances that you can think of in recent years where somebody has served time? Because you said it's possible where they could serve time but still not be honorably discharged, where they have served time and been convicted of these types of physical and sexual assault and served time. Have there been cases of that, or that you can think of? I know that there's restrictions on what you can and cannot report on, but
I was just hypothetically suggesting that on an active duty case, somebody that, for whatever the offense is, if they were given time in a military prison and then discharged, it still may not be a dishonorable discharge. Okay. We don't do criminal prosecutions under the Military Code of Justice in the state of Maine. That's left to the civilian courts. And so we don't have prisons. Like I've said, we don't have criminal investigators. We don't have military judges. We don't. We only use that code for non-judicial punishment. So I don't know if I'm not sure if that answers your question, but
it actually, what you just said is really helpful for me. I guess I was trying to gather whether yes, it didn't answer it, but it did answer it. So
okay, as long as you're set, I'm glad. If I answer a question by mistake, that's just as good as answering the question, right? Okay.
You're muted, Senator.
Thank you. Thank you, Representative. My phone rang and it wasn't on silent. Janet, if you could please stop sharing your screen. So the only other page of the bill analysis that we haven't touched upon at all is page 6, the additional issues raised in testimony. So if you could, Janet, just walk through those 8 items. Then after you walk through those 8 items, I will direct a few things to happen. We'll take a break, and then we'll come back and we will tie up all of the loose ends and have a motion and a vote. We can't really do anything until 2:30 around voting, but I have some ideas about how to spend that half an hour. So Janet, if you could please walk through the additional issues raised in testimony. We still have Attorney General Fry here. If we have any questions for him, of course, the General is here. And I know that District Attorney Maloney may also still be in the attendee room. I wanted to put her back there in case she needed to use her screen for something else while we were working this out. So here we are, additional issues raised in testimony. Some of these we've probably already talked about, but because Janet did the work, let us share.
Certainly. So I did just want to say that the last chart I shared with you is the only thing not in the electronic committee file. So I tried to show you, although I didn't say it out loud, that you can find that directly on the Maine Bureau of Veterans Services website. That's their benefit eligibility chart. They made it, not me. Everything on the left is hyperlinked. You can find a ton of information from that chart. So if you're watching from home or somewhere else, that's where you can find that information. And they have a ton of information for you if you follow all the links.
Thank you.
So when I looked through what was in the written testimony and what my notes were of the oral testimony, there may have been other things, and if you mentioned them, I apologize for missing them, but these were the things I saw that were raised as other ideas. One was to create a fund to pay for counseling and other mental health treatments for survivors. Another was to prevent survivors from losing tuition assistance and other benefits as a result of the trauma caused by military sexual assault and sexual harassment. And the chart you just looked at shows that there's a lot of different benefits. As the Adjutant General said, some are state benefits, some are federal benefits. There's a whole host of different benefits. They all have different requirements. And I just tried to think off the top of my head, what's an example of one that the state has control over, and that's applicable to National Guard members, and that's the Maine National Guard Education Assistance Program. So I just wanted to give you an example of how that suggestion would play out in statute. So under the current statutory rules for that tuition benefit, it's 100% tuition benefit at a state post-secondary education institution for members of the National Guard who are in good standing and have completed basic training or received a commission, who have not yet received a bachelor's degree, and who agree to serve in the National Guard for at least 1 year beyond the end of the term of the tuition benefit. Under the statute, these benefits cease and the member may be required to repay them if that member fails to maintain a good academic standing, which is at least a 2.0 out of 4.0 GPA scale, if they fail to complete the term or semester, or if they accumulate 9 or more unexcused absences from unit training assemblies, or if they fail to attend or complete the entire period of annual National Guard training. And I'm sure the folks from the Adjutant General staff can explain if I missed some of the other things, but those are the requirements I saw that may have played out in having some people lose their tuition assistance after experiencing one of these incidents and the trauma that resulted. Another suggestion from the testimony was to provide for administrative discipline or other consequences of record for commissioned and non-commissioned officers if sexual assault or sexual harassment occurs within units under their command. Another suggestion was to provide a method for members of the Maine National Guard to report sexual assault and sexual harassment to someone outside of or external to the Maine National Guard. Another suggestion was to require the sharing of climate culture surveys with members of the unit to help them understand how their peers view the culture within the unit, with university researchers who can make recommendations on improving the climate of the National Guard, and with this committee, along with a requirement that the Adjutant General develop an action plan with measurable outcomes to improve the climate each year. Other suggestions in the testimony were to require the Maine National Guard to prepare something that the testifier called a readiness report card, which would measure many aspects of unit readiness, not just the topics before you today, but that would include, for example, the percentage of soldiers who pass required physical fitness and weapons tests, how many soldiers have completed various types of required trainings, and more pertinent here, indicators from the climate surveys. I think that was the specific thing that was related to this this whole topic before you today, and any other kind of readiness measures that could be included, or that you all decided to include, or the Adjutant General decided to include. Another suggestion was to develop formal and informal, and from that I noted it was outside of the command structures, appeared to be what the testimony was suggesting, methods for soldiers to report incidents that lead to negative culture in the unit. So not just formal sexual assault or specific incident of sexual harassment, but just negative culture incidents as well, to follow up on those. And then also suggestions for increasing and improving National Guard trainings for the protection of sexual assault and sexual harassment.
Thank you, Janet, for sharing this. I wondered, General Farnham, if you have any objection to perhaps, and this is also for the committee to answer as I ask it of you, that we would maybe direct in unallocated language you as a part of, or your representative as a part of the advisory council, to add these as additional considerations for the advisory council to review in its work, since we certainly cannot direct the actions of the advisory council since it's not a creature of the legislature, but we could direct somehow that these get considered as a part of the work of the council. And Janet, you can stop sharing your screen. Thank you. That is a question for both the general and the committee. The chair recognizes Senator Farron.
Thank you, Mr. Chair. Before the general jumps in there, I looked at, going over some of those things that were thrown out there about weapons qualifications, the amount of training and a bunch of things like that. And it's like, first of all, I don't know who on the committee, is qualified to assess some of those things. And second of all, every unit location has different training requirements. I mean, I don't even know you'd understand what you was looking at and how that would be compiled, getting down to those level of details. And quite honestly, as I'm listening to some of this stuff and what we're digging into, I really wish this committee would spend as much time going and visiting some of the units and seeing the great work that our soldiers and airmen do, and getting some of that climate and the pride that they have in wearing the uniform and serving with us. So some of those details of reporting, I just don't think is very realistic, that first asking the department to put it together, and second of all, what this committee would ever do with it.
Senator Farron, can you be more specific about what on that list you're talking about?
I mean, weapons qualification, physical training requirements. I was telling somebody this morning, I know it's changed. Hey, listen, I've been retired since 2013, so lots of things have changed, as the general has mentioned. But I remember, a lot of these folks are drill status guardsmen. They have a full-time job in the community, and they've been deployed a bunch of times or whatever, but they're your neighbors. They're the folks you see at the gas station on your way to work in the morning. And they're lucky if they get 2 or 3 days a month. And I remember drill weekends when, we had 32 hours of training that we were supposed to get into a 16-hour day. So if we're just trying to make more reports and things, it's about the culture, folks. I still keep going back to that. That starts at home and schools and society. This is not just focused on the Guards. So to answer your question, Senator Hickman, I think some of those training requirements, the reporting piece back from the department to this committee, I just don't see whether that is very realistic.
Chair recognizes Representative McCray.
Thank you, Mr. Chair. I really do agree with Senator Farron on that item. I think that's outside what we're trying to do here. And I have visited, and I agree, the pride is, I don't know the right word. It's very apparent, as it was in the testimony, that people are proud to be Guard members. I do, though, think that some of the others are I would feel very appropriate to mention in unallocated language. These would be helpful. One of them that we heard about was loss of tuition as a result of the trauma. The tricky part would be how to demonstrate the connection, but I don't think that's for us to decide here. I think it's a question that I would like to see explored. Making sure there's support for counseling. I don't know that palpable. Yes, thank you. I don't know if that is already there or not. The climate surveys, maintaining confidentiality and specific to this issue makes sense to me in some way, but I think that's for the advisory. I would like to see the advisory committee dig in on those things and report back, and what are next steps to continue progress, keep more progress, and do better. Thanks.
Thank you, Representative. And just for clarity, I wasn't asking for General Farnham to report back to us on each of these things. It was for the committee to decide if we go with leaving the Executive Branch Advisory Council as a standalone advisory council and maybe not putting one in statute. What would we be asking for members of it to perhaps consider additionally to what are already listed? And so this was just a list of things that came from testimony, and clearly some of it isn't germane to the work of the commission. Like requiring readiness report cards is certainly outside of the purview of this committee and probably even the advisory council, because that's internal training for the National Guard. So I certainly agree with Senator Farron about that in particular. Janet has her hand raised.
I realized I forgot to mention something earlier when we were talking about the advisory council. So obviously you can have your own advisory council. It can be as similar or dissimilar to the one created by the governor as you wish, or you could choose to go forward with the governor's one. And as you've been talking about, maybe make some recommendations for things to consider. One other thing I did forget to say was you can't direct the advisory council. I know I mentioned this, to do something, but there are people on the advisory council. For example, one of them is in this room today. The commissioner or his designee would be a member of it. And for example, I was just trying to think of all the options before you. One thing you could say is there is this required report in December under the executive order. You could direct, I wouldn't think that the governor wouldn't share it with you, but you could direct the commissioner or somebody else who's on that council to share it with you just as an independent freestanding direction, so that that report comes to you. And when you write that, because you're writing it, not because you don't trust the people to share it with you, I'm not suggesting that, but then you have an opportunity to write, and then the committee can report out legislation. So something to tie that to. So there are different ways you can approach that, and I just forgot to mention that.
Thank you, Janet. I was trying to get to that, but it didn't come out right. I was trying to direct a member of the advisory council to take into consideration some things that we would ask that person to bring to the council. And now Janet is saying if we were to take that approach, we could then say the committee could report out legislation based on whatever the council came up with regarding those issues. So we have a lot to consider. I'm going to, it's 2:15. So I want to go back just through the bill analysis and tell folks what I think we may be including, I say may be including, in an amendment to the bill. So it sounds like from everything I've heard so far and what my notes suggest is that we would go ahead and draft a very comprehensive amendment to Title 17A, 506A, and any of the things that are cross-referenced in Janet's analysis to strengthen that part of statute. I would, General Farnham. You may proceed, sir. I didn't see your hand up.
That's fine, Sam. I thought you'd wanted me to comment on those
items
you guys are just talking about. And I just, the only thing that comes to the thing that comes to mind on that is some of them get kind of specific. And if I remember right there, they're basically based on a comment by some of the testimony the other day. And so my recommendation would be to leave that as generic as possible. For instance, the tuition assistance thing is part of a bigger discussion on some of the benefits. And most of those concerns have been fixed in the last number of years. And again, without getting into specifics of that individual case, things would be, things would be different today, for instance. And so I think as the committee's looking into a lot of things, not just the couple of things that were mentioned, there's a lot of those types of things that are different today than they were just a couple of years ago, and especially 10 years ago. So, if you get too specific in that, the answer is going to be that's not even it's NA. So
yeah,
it's been fixed, it's been taken care of. So I would just suggest that I think that's what somewhere between the advisory council, relationships with community organizations, and the report that comes to the legislature from me with coordination from the outside organizations, all these things get touched on. It's just, so if I was going to start making a list of specific things that we need to talk about, it's a lot bigger than that. And some of those wouldn't be on it because they're really not even a player now, just because of changes that have come about.
Great. Thank you for that, General. Are there any questions for the General based on what he just provided as feedback? Seeing none. So it looks like, again, we can incorporate an amendment to the harassment criminal code. That's comprehensive, as Janet has laid out. And the answer would be yes to the question you asked, Janet, about how far do we want to go all the way. I would then therefore recommend a section of the bill to include a new section in chapter 37B. It would be section 461A, and it would be entitled harassment. And it would be structured the exact same way that 461 is for sexual harassment. And it would just cross-reference the appropriate 17A provisions that are being amended in 560A and elsewhere. Janet, if I say something you don't understand, just please tell me. We would be considering adding a position to the Maine Commission on Domestic and Sexual Abuse. And in order to take and we would follow the guidelines from Lucia Hunt about how to say it. We would also amend the membership in item line 10. It's on page 9 of the bill analysis to change up to 4 members at large appointed by the governor to up to 3 members at large appointed by the governor. And we would put the new specific person with a representative or member of a military community wherever it fits on that list. That would be included. And we would funding to attend court administrative proceedings. The general has basically said that so long as the language is restrictive and not all encompassing, that could be done within existing resources. That could be in an amendment. Let's see. I think the cooperative agreement section isn't necessary unless I'm missing something. I'll let folks talk about that if I'm missing it. We would definitely on page 5, go with the annual report the general just referred to, making sure that it is, again, not the language takes into consideration all of those privacy concerns. Again, then the big sort of question for debate for the committee is whether or not we have a separate advisory council or we just leave the advisory council alone and perhaps add some unallocated language if we want or not to suggest some other considerations for it. And then probably most importantly, we would write unallocated language for the Office of the Attorney General. And I would actually ask while we take a break that if Janet has the time and space, and if the Office of the Attorney General has the time and space to just draft a simple paragraph about what that would be, because the Attorney General is making it clear that his office can do it with existing resources. And so we want to make sure that what it is we're asking the office to do and the report back to the legislature would be within those existing resources. And so unless there's an objection from the Attorney General or from Janet, we're going to take a 20-minute break anyway. We'll come back at 3. We'll come back at 3 o'clock, and therefore we can have an idea of language. Since we are where we are in the schedule, I don't know that there are all that many people on this committee who would be comfortable just voting out a concept. We need to see a little something about what it will look like. And we're therefore going to have to ask everybody to work quickly and collaborative together before 3 o'clock so that we can come back, discuss it, see if there are any other items we should add or take away, make a motion and take a vote, and be done with our work for the day. Are there any questions or concerns about this way forward that I am putting forward? Did I miss anything, committee? Okay. So we'll come back at 3 o'clock. And like I said, between now and 3 o'clock, I think it's just important for first Janet to work with the Office of the Attorney General to get some language around that right. And then any other language that she may need to work on. My phone is here. And we'll try to figure something out between now and 3 o'clock. It obviously won't be in any final form, but to have something that we can see was going to make everyone comfortable. Anything else? Great. The Joint Standing Committee on Veterans and Legal Affairs will be at ease until 3 o'clock. Good afternoon. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. We are a little bit late, but that happens when we are at this point, at this stage of a bill's work session. So we will wait to see 7 faces from the committee. 1, 2, 3, 4. Senator Miramon, if you're here and can hear me. One, two, three. And I know that Representative Wood, I saw her face earlier as well, which we will absolutely need Representative Wood. Let's see if I can. There she is. So the Attorney General is still here with us, thankfully, and General Farnham is still here with us. We have 2 TAGs with us today. Don't know if that happens often. Representative Wood, are you able to turn on your camera in case we need to take a vote? I just want to make sure that you're here and not just sort of kind of here. Well, until we figure that out, Janet, there she is. Is with us. Hey. So
I
Janet,
can take a vote, and
okay,
I'm listening.
great, thank you. Thank you. Appreciate that very much. So Janet, if you could please, thank you all very much, obviously, for your due diligence on this subject, on this issue, and for the work done in the interim from 2:30 till 3:15. So Janet, if you could please share your screen with the outline of my proposed amendment for the committee's review. And then we can talk through the parts of it that we still have some questions about. So go for it, Janet. Thank you.
So this is a Word document, not just because that was how it was made, but then I thought you could all see it and tell me to change it as we go. As my understanding, what Senator Hickman proposed was that the cease of harassment orders that a commanding officer in the Guard might issue to someone would be kept as they are in the bill as a ground for prosecution for criminal harassment if somebody continues with the course of conduct after receiving that order, just as it's laid out in the bill. It would also be adding to the bill, making that a ground for the filing of a complaint for protection from harassment to the same extent that a law enforcement's order to cease harassment is a grounds for filing a complaint. So that's a really shorthand version of what's explained at much greater length in the bill analysis, but that's what I understood him to want. The second point was to add the crime of harassment to the Maine Code of Military Justice. So this would be that 17A 506A crime that would be added within Title 37B, and it would be modeled on the provision you all saw that makes sexual assault an offense under the Code of Military Justice. And the purpose of this would be, at least for the short term, because only non-judicial punishment is offered under the Maine Code of Military Justice, as I understand it currently, that would allow for that. If in the future that changed, this offense would be there and be able to be used for any of the punishments that would be meted out under that code. The third part is the Maine Commission on Domestic and Sexual Abuse. You would add a governor-appointed member to the commission who is a member of the military community with experience in sexual assault response. I believe those were Lucia Hunt's suggestions. And then you would reduce from 4 to 3 the number of governor-appointed at-large members. And then I cited the provision here, and I can refer you to any of those statutes. Anybody wants to see them to just make sure. For travel reimbursement, I just quoted this directly from the Adjutant General's response to the questions that you posed today. These are all posted online. This is the document that has a lot of yellow highlighting on it. So this is exactly what he wrote here, that the funds for travel reimbursement would be used for administrative or Maine Code of Military Justice proceedings related to the sexual assault or sexual harassment. As far as the cooperative agreement, Senator Hickman, I wrote this a little differently because Senator Hickman said he proposes removing it, but he wasn't tied to that. He wanted the committee to discuss it. So that's why this is written a little differently, because it was literally a proposal for further discussion. As far as the annual reporting from the Adjutant General that are in section B11 of the bill, I tried to summarize what the Adjutant General's concerns were, that you wouldn't want it to violate any federal regulations about privacy of any of the data or information. And already the bill says that the information shared with the committee and the reports must not violate any of the requirements of state or federal law about privacy. So he had suggested adding federal regulations. I would do that much more artfully than it's written here. And then also, he had pointed out that it might be important to or necessary to summarize some data based on a need to avoid any information that could lead to identifying victims. So that's how I put it here. He also mentioned orally that following the requests of the victims, that if they want their information kept confidential, but I think the way all of this is written, it does already do that, because the federal laws about the way you reported it would be implicated in the federal regulations. But if that's not true, I am sure the Adjutant General's office will contact me as drafting the amendment and say, maybe fix this up a little bit here or there.
I saw a thumbs up, Janet, from General.
Okay.
So.
As far as the advisory council, Senator Hickman did not suggest an outcome. So I just literally tried to think really quickly of the kind of things you would have to think about. So if you wanted to create your own advisory council, you can obviously use the version that's in the bill now, or make it a little bit more detailed. You might want different members. If so, who? You might want to specify terms, or you could just say at the pleasure of the governor. You might want to change some of the duties from the few duties that are listed in the bill right now. You might want to look at the reporting requirements. It's an annual report. Perhaps that's sufficient as the way the bill's drafted, or maybe you want to change that. Or the other option that has been discussed today is to not have the advisory council in the bill itself, because the governor has an advisory council by executive order, but to put some unallocated language in the bill that would talk about either requesting or suggesting, not ordering, but requesting or suggesting that the advisory council consider certain things. There was a list of things that people had suggested during testimony, but it wasn't clear to me which ones of those you wanted to include. So I thought we could fill this in together if that's where you want to go. Or either one, directing a member of the advisory council. You'd have to pick a state official if you're directing them by legislation. So I had suggested the DVM commissioner, but it could be someone else, to submit a copy of the report that's prepared in December of 2022 by the advisory council and submitted to the governor under the executive order. You could direct that report be submitted to you, not because you think that people aren't going to be willing to share it, but because then you can say, and the committee can report out a bill in response if you want, if that's important to you to include. And then I did speak to the Attorney General's office, and since sending this language to you all via email, they have added some changes. So I show them as struck through and underlined. So the Attorney General has communicated to me via email that he would be comfortable with this language, and he wouldn't think on an initial glance, I don't think he's promising forever, but his initial reaction is positive and might not require additional resources. And this is modeled on the language that was in the Alaska report that you talked about, to have the Attorney General's office investigate allegations of sexual abuse or sexual harassment. Because sexual harassment isn't a crime in and of itself, he did add language referencing the crime of harassment, so that if it rises to that level of a crime, otherwise there wouldn't be a report to law enforcement necessarily. So allegations by members of the Maine offenses by members of the Maine National Guard against other members of the Maine National Guard during a 5-year period that ends tomorrow. That was just a suggested date. That are reported to, and then the idea would be to take out state or local to just say law enforcement, to make sure you cover everybody and not try and guess at everybody, or prosecutors, and then examine the nature of each allegation investigated, including information available and not available. This is directly from the Alaska language. I think that means like information they were able to find and not able to find, and we can work on clarifying that language later. Also examining whether the allegation was adequately investigated by law enforcement. I forgot the state or local here. And if any improprieties occurred, whether law enforcement reported, whether the reports by the law enforcement were forwarded to the prosecutors, as D.M. Maloney had said should be automatic, and whether the reports included a recommendation on prosecution. Again, that's language from the Alaska study. And also studying whether appropriate action was taken by the prosecutors. And this number 5 is changed a little bit from the Alaska provision. So it would say whether, if requested and appropriate, the results of the investigation by, again, just law enforcement, well, I'm not going to cross it out now, were communicated to the appropriate National Guard authorities for the purposes of taking further action, because there have been discussion about that the National Guard might follow up with its own administrative discipline in certain instances. And then also the last item that was in the Alaska studies include recommendations for handling such matters in the future. The Senator Hickman had said that there was one provision of the Alaska report that he didn't think was necessary, so that's not included here. One other thing from the Alaska study that isn't included here is an opinion on whether any of the cases require further investigation. My discussion with the AG's office was they wouldn't want to give like formal opinions on whether somebody did the right investigation or not. So that's where this list came from.
Thank you.
All I had so far.
Thank you, Janet. Excellent work. Can we go back up to 7 just to open up a conversation? So the question that we have is, if we were to, shall we say, for lack of a better phrase, copy and paste the Governor's Advisory Council into statute, what problems would that cause, if any, and how could we address them if they caused any problems with function?
Well, are you asking me?
Yes.
Okay, sorry. You can put in statute whatever you want to require for an advisory council. If it turns out it looks exactly like the one that the governor created, it's possible that the meetings that would be conducted would be considered meetings of both at the same time. To the extent there are any differences between the two, it might require dual meetings because you might have different membership, for example. I would think that they'd need to have those meetings separately. It'd be up to the governor, obviously, whether to continue with the one under the executive order. You don't have any say in that. If the duties are slightly different, that might be a little bit complicated, but what you can't do is say you are codifying in statute that advisory council. That advisory council is a creation of the governor. You can create your own, and it's just if it looks very similar, it might be more expeditious to have the meetings run at the same time, if that makes sense. But one would be a creature of the legislature and have to be literally thought of as separate. For that reason, I would suggest not using the same exact name so that it's clear you're making your own advisory council, if that makes sense.
It all makes sense. Can I have the committee members please comment on what Janet has just guided us to discuss? Chair recognizes Senator Farron.
Thank you, Mr. Chair. I really don't see a need to have two councils, and I know we talked about, you know, putting it into statutory piece so that we know that it was done going forward. You know, if another administration or whatever didn't follow through. My other concern is that, and I think we talked about this a little bit, is that if we have the advisory council in this bill and it doesn't take effect until 90 days after we adjourn, whereas the governor's executive order and her council is supposed to have something out in December, sooner the better, right? We all recognize that this is an issue that needs to have the discussion. So my personal thought would be that we'd go with option B and do the unallocated language and also have that direct the member of the advisory council come back so that we have the ability to report out legislation from that piece. But that's my 2 cents.
The chair recognizes Senator Miramont.
Thanks, Mr. Chair. Well, I like what the senator has to say, but I do want it in law. And If there was, if the governor's advisory council was to be ended, I would want ours to continue, but I am willing to think about it being for a certain amount of time because it's supposed to get at the problem. And so is all this much awareness on the problem. So if we had it that it ran for a certain amount of time, then could be renewed if necessary, that would be another matter. And I'll think about what Senator Farron just said too, but that's my 2 cents at the moment. And it would be fine if it was pretty much the same language with a different title for the advisory council so that they could have the same meeting, but it wouldn't end if a new governor came in and decided it wasn't a problem, because there can be a lack of awareness about the problems of the state by different people. Thank you.
Chair recognizes Representative Supika.
Thank you. I was gonna say what Senator Miramont said, that I would be supportive of using the mirroring language and trying not to make any issues where there would have to be 2 meetings happening, but the goal being that it goes forward in the future in years to come, that it continues on. So that's where I'm at.
Chair recognizes Representative Riley.
Yeah, I mean, I agree with Representative Supika and Senator Miramont. I mean, I'm perfectly fine with like mirroring the language and putting the governor's advisory council from the executive order like into statute. So again, we can have it go from administration to administration.
Are there any other comments about 7? So thank you all for engaging on that. I think that it could create an issue because it would actually be another advisory council, even if it was set up exactly the way it's written in the governor's executive order. If we put it in statute, it's created by the legislature. I would have to think about how that would work. It's not clear to me that it would. I absolutely understand the concern about codifying a statute to make it here. But it would be a different council. I mean, let's just be clear about that. It can't be the one in the executive order because it's not created by the legislature. So if we created something, it would be a separate council. It would be 2, no matter how we slice it. So I will say that I'm personally leaning toward some unallocated language to direct a member of the advisory council who is a state official to submit a copy of the report back to the VLA committee to give us the authority to report out legislation. And the reason why I'm leaning toward that, just for folks to know, is because we could use that legislation to put something else in statute that would even be better once we know more about what comes out of this one. The fact that this council has to do something by December is encouraging. It's a date where we may not be the legislature because by December we could have a new legislature. So I do understand that none of us may be here to receive that committee report, since when the elections happen and when people are sworn in, I would imagine that that would be the 131st legislature that gets that report. That could also mean that no one is here, even if the report is submitted. But that's a creature of the way we work. Even if we would put it in statute, the next legislature could repeal it. So nothing is permanent in the legislature. So we can think about that more before we include something in the amendment. Let's move on to 5, where I propose removing section B10 of the bill as unnecessary. What do people think about that in committee? Anyone have any objections to removing that from the bill? How about I ask a question? Does anyone have any objections to removing section B10 from the bill? Seeing no objections, we will remove section B10 from the bill in an amendment we may vote on here soon. Thank you, Janet. So now let's go to 8. The District Attorney General to perform the following review. Attorney General Fry, if you are with us, may I ask you a question, please, sir?
Yes, I'm right here, Senator.
Thank you, Attorney General, for being here. Can you tell me, the committee, how much time you would need to report something back to the legislature?
My contemplation was that it would be sometime, it would be at the beginning of the 131st legislature, right? So it would be in time for the committee to pick it up and consider where to go with it. So that would be what, 8 months?
February 15th,
so.
2023?
Yeah.
February 15th, 2023? And so if we were to put language in this unallocated language section that you would report back by February 15th, 2023, and give the committee the authority to report out legislation based on your findings from the review, would that be something you could live with?
That should be fine. Thank you for asking.
You're welcome. Are there any comments or questions from the committee about this particular provision of the possible amendment? Chair is going to just sort of ask Senator Farren if you have anything to say about this or not. I'm putting you on the spot, but you don't have to answer.
Me on the spot? Never. I struggled with this just a little bit because I was thinking that we could just ask the Attorney General to do this and report back to us. But I guess as I've thought about it a little bit more, I understand that if he reports back and we want to have the opportunity to report out legislation, we need to have it in statute. So I think I'm okay.
Thank you, sir. So let's go back up, Janet, please, to number 5. I am going to invite Elizabeth Ward Saxo to join us. If you could stop sharing your screen, because I believe her hand went up when no one on the committee objected to removing that section from the bill. I may be wrong about that, but since she has participated in this process with us from the beginning, I will certainly receive information from her at this time.
Thank you, Mr. Chair, for allowing me to come into the room. So in fact, my remark was about the investigation. If you would be willing to hear a comment on that subject, it is not on the cooperative agreement.
Okay, great. So the Attorney General's review, is that what you
Yes.
are? Okay, great.
Yep.
Go ahead.
Okay, great. Thank you. So when the Attorney General made note of the fact that when he put in the definition of harassment there, that is not sexual harassment, that is the criminal harassment, right? And so what we are not picking up is the full range of what can be egregious sexual harassment, but which is not a crime. They're the kind of things that would be handled by the Maine Human Rights Commission, for example, if the institution was not a government entity. And so there was just a lot of conversation I heard through the work session, the previous work session, and in the public hearing around the full range of kinds of behaviors, from really basic sexual harassment to full-blown, gross sexual assault as defined in Maine statute. And so I just want folks to be aware that that's a piece that would be left out. And I think that's one of the reasons why the other state model you're looking at was sort of bifurcated in terms of who would investigate which piece of it. So that's all I have to add on that. And then I just wanted to also note that if you end up with 2 commissions, I know I am not the only person who would be in this position, but one of these commissions plus the cooperative agreement work is a very heavy lift. 2 commissions, if they happen to have to be separate in some way meeting, would be a very, very heavy lift. And that's all I have. And thank you for allowing me to speak.
Thank you, Elizabeth Ward Saxo. This is a question for anyone who can ask it, and it may be you. Is there a definition for sexual harassment in the criminal code? Or is there
There is not. No, where it exists is well, it now does exist somewhere in statute, and I think it's actually in housing law, where they brought in, I think, the definition that the Maine Human Rights Commission has in, ooh, Janet, I think it's in rule for what sexual harassment is, but that's the most standard definition. The one that that we use in Maine is the one that the Maine Human Rights Commission uses.
I understand. I think I know what you mean. I think that for the purposes of this bill, then we're not going to create a new crime for sexual harassment. We would just make it clear in the language that we are considering that it's harassment and not sexual harassment. And so that area of space, I don't know how the committee is going to deal with that and what the Office of the Attorney General reviews. That may be a part of the report back to the committee. I don't know if we need to direct the Office of the Attorney General to work with the Maine Human Rights Commission to try to cover that nebulous space or not. Do you have any thoughts about that, Elizabeth Ward-Saxel?
I mean, I personally think it's really an important space, but I also think it is where the real costs would come in an investigation. And so perhaps there's a phase 1 and phase 2, but I do feel like it's probably more likely an area where there are still a range of issues where in some of the other spaces, there may have been more significant improvements over the last 10 or so years, 10, 20 years.
Thank you. So Janet, we will definitely—
That's our perception from the outside.
Thank you very much, Ms. Saxel. Does anyone have any questions for Elizabeth Ward-Saxel on this matter? So Janet, I would just recommend we take out the word sexual from what we're going to ask the Attorney General to do, because harassment is still an important thing to consider. That's a crime, which also dovetails with the new section of the Maine Code of Military Justice that we're adding as well. So we'll have to get to a different definition for sexual harassment some other day. No one is suggesting that it is not important, but it is my understanding from reading the crime on harassment that it doesn't prohibit or exclude sexual harassment from being a consideration where the crime is charged. Is that correct? That's what I thought. So back to the section, what is it, 5 or 6 of the proposed amendment regarding the council. Where are we at, team? I mean, we're not rushing, it's late, I know, we're almost there. It sounds like a heavy lift to have 2 different councils at this point in time. That's just my opinion, but I'm one person. The chair recognizes Representative McCray.
Thank you, Mr. Chair. Yeah, my feeling is absolutely we don't want 2 councils. But my feeling has been all along, and I think this is the point we have to come together on, because I think we're almost together every place else, is putting it in statute or not. And I guess I don't understand why that would create a second council. It's exactly the same council. We're just saying we're putting it in the bill. And my only concern was, by doing that, were we slowing the process down? And I've been assured that that's not the case. The council would do what it does. And I just still don't understand why we wouldn't put it in statute to make sure it's in statute. We'll get the report back, whoever's here on the committee. This would be the committee of reference unless something dramatically changes, but I think it would be this committee. And we would have the authority to say, let's keep it going. I mean, it's written to keep going, but we would be assuring that what I would want is to be assured that we have that option as a legislature. So again, I'm still questioning why that would be problematic, but I also want us to come together and again, we're almost there. So Let's figure this out.
Janet?
I'm just trying to think aloud here. First of all, in response to your question, Representative McCray, you have to think of it as technically being a separate advisory council, even if the governor chooses to hold the meetings jointly, because you don't have authority to put her advisory council in statute. You can create a legislature created advisory council. It may in fact end up being the exact same people on the exact same day talking about the exact same things because that's how it's conducted. But you have to think about it as you're creating your own because you can't take hers and create it in statute. I know that's what you're going to do, but you have to think about it as separate because of separation of powers. The only other thing I can think of, because it sounds like people are trying to come up with ways to get everybody on board. I could be misreading the room because we're not really in a room, we're on Zoom. But the only other thing I can think of is the Adjutant General, you have an annual report. You could put some kind of interesting language that I could think of later about the Adjutant General reporting to you on the activities of any advisory councils that might exist. And then if the current Adjutant General, he or she reports to you that there isn't one, you can report out legislation creating one that triggers everybody to think about it. I don't know if that makes people happy or not. It's just another option I'm throwing out there.
Thank you, Janet, for throwing out the option. General Farnham, would you like to comment?
Yes, please. Thanks, Senator. I was kind of thinking along those same lines as in my mind, as we had talked about this earlier, you know, I've got these different columns that are areas, whether it be the piece that the Attorney General has as far as how law enforcement interacts, the piece that we talk about with the National Guard Bureau and how, you know, and how our policies are in place, the piece with the community agencies and that commission and what the advisory council brings to the table. I kind of looked at them as kind of different silos that then would be brought together based on their reports and based on the report that I give to the legislature each year, because that would be the place that kind of brings that stuff all together. So, you know, kind of along the line of the confusion of having two, if there was a kind of a wait and see what the advisory council says, see what Attorney General Fry's report says, and then we look at it and we say, hey, is this advisory council that was in the governor's executive order, is that really what's the best thing going forward? And then working with the governor's office, and you know, maybe then that's when you put in not just a mirror of that EO, but you put in the right type of council that addresses the right types of things as we all work together based on what we've learned. Because, you know, at this point, you know, there's a lot of stuff happening, but all the information that we're going to learn from these reports, we don't have yet. And so that would be, I mean, in my opinion, to speed things up, listening to everybody, get the information, then say, what do I need for a forever council going forward? But that could come out of, as we consolidate everything in our department report to VLA in February. That's all I've got. Thanks.
Thank you, General Farnham, for your input. Does the committee have any thoughts or questions about what's in front of us regarding this issue? I mean, I'll just say I made it clear from my perspective. There we go. Then I don't have to say another word. The chair recognizes Representative McCray.
I didn't mean to get you off the hook.
You got me off the hook.
I guess I just want to say that, I mean, clearly there's commitment here to take action. And I want to, you know, I hope that the people who have testified, who have asked for this, as well as all the people that we've talked to today, are feeling like whatever we do, we're doing positive steps and doing our best to do what's right. So I guess that's weighing a little heavily on me, that I want to make sure that we're representing those we represent. And again, I'm better understanding the nuance of the two committees and the alternative of the report. So I need to kind of see how everybody else is feeling, but just want to say nobody is saying we don't want to do this, we shouldn't do this. It's doing it the right way and being within what the legislature does, which is always very interesting. Thanks.
Thank you, Representative. The chair recognizes Representative Riley.
Yeah, I agree a lot with what Jay expressed there. I mean, top concern is I just want to make sure that survivors have a permanent seat at the table from starting now and continuing on to go from administration to administration. I mean, I think I think everybody here expresses that, but that's my top concern.
And may I, Representative, ask you a question about, they do have a seat at the table on the executive branch, the governor's council. Is there some other place where they are absent from the table where we need to consider having a seat that we are working on today as well? I'm just throwing that out there as a question. You may answer.
No, I mean, it goes back to, again, if just having something in statute in case there's, again, changes later down the line from the council.
Okay, I see what you're saying. The chair recognizes Senator Farron.
Thank you, Mr. Chair. Just listen, been a long day and been a long week, right? And it's only Wednesday. And obviously Janet, the department, the Attorney General, everybody has put a ton of work into this, and I think we're there, or almost there. And I'll just tell you straight up, I will support everything that we've done here, including it with the recommendation that we don't create two councils, and follow the recommendation that Janet kind of laid out and General Farnham articulated better, that we give the OIC investigation, we get the Attorney General's piece, we get the Governor's Climate Council back. Hey, yeah, climate, that's what I said. I got that. I'm on that group too. I'm on the Transportation Climate Council, so they all run together. But we get all of that information back, and whoever among us survives the election in November, and we're back in the committee on the 131st legislature, and the general comes back and reports and says, these are the recommendations from the governor's task force. This is from the OIC report. This is from the Attorney General. And if we decide maybe another commission's got to be formed or a bill's got to be reported out, unfortunately, fortunately, that is the way that we only work from one legislative session to the next, and the next one can change whatever we do. And so we might want to have this long-term thing, but you'll learn after a while down here, you can do what's in front of you right at the moment. So I think you've done good work. I think Representative Riley bringing this forward and having the conversations, and I'm ready to move on.
Jenny, can you please put the amendment back up on the screen? And I am going to invite, I see a hand raised in the lobby. And so if you could take your screen down, sharing, Janet, I didn't know this was happening, and I'm just gonna be nimble and work with the moment. I'm going to invite Rebecca Cornell Dahu here to see if she has something to offer us as a representative of survivors in the moment. In the moment and at the moment. So Rebecca, please introduce yourself when you arrive through the wormhole.
She may not have heard you when she was transferring.
Pardon me, Janet?
She may not have heard you as she was moving.
You're right.
Senator Hickman, can you hear me?
Yes.
Okay, my apologies.
Please
Yes,
introduce yourself just for the record. Say who you are. Thank you.
okay, absolutely. My name is Rebecca Cornell DeHue, and I am the executive director of the Sisters in Arms Center. And I know myself and some other survivors are listening in on today. And just to Representative McCrate's statement, I want to just say that we are definitely listening. We definitely see and hear all the hard work you've all put into this and are incredibly grateful for that. And also the TAG for working together on this. And the other thing I want to say is, as long as, you know, to reiterate what Representative Riley said, as long as like we have a voice, honestly, on the table on whatever advisory council that forms, I think that's the most, necessary thing, so that we can just continue to provide that perspective of survivors. Thank you.
Thank you again for being here, for all of the advocacy that you have done on behalf of so many. Does anyone have any questions for Rebecca, so long as she is here and weighed in on what we're doing? Seeing the chair recognizes Representative McCrate.
Thank you, Mr. Chair. Not a question, just a thank you.
Okay, great. Yes, thank you. So now, Janet, can you please put our proposed amendment back on the screen? So I guess where I really am standing, there is a seat at the table on the Governor's Advisory Council for survivors. That's true. And I want to say that out loud again, not to appease anyone or make anyone feel any which way, but that is a fact. And we will be getting a report back in December from an advisory council that includes a survivor of sexual assault in the military. So when I look at number 7, it seems to me that B2 is a way to direct a state official that we can direct to submit that copy of a report to this committee and gives the committee an opportunity to report out legislation based upon that report. We will also have the opportunity to report out legislation based upon what comes back from the Office of Attorney General's review. And whenever the OCI investigation begins or ends, which General Farnham has made clear that it's not clear exactly when that will begin and end, because there is some transition happening. General Farnham, is that a safe thing to say? I don't want to speak for you. That's how I understood what you had to say. Janet, if you could take your screen down now, I'd appreciate it. Thank you so much.
So it was more just trying to, they are ready rather quickly. It's just a matter of, I think in the legislation and the statute that, or the edits anyway, ahead of February. So if we just looking for kind of the right spot so that it fit properly with all the changes that are coming in the program. You know, again, I don't want to, if you do it too late and a lot of changes have already just been implemented, the answer to every question is, well, that doesn't apply anymore. That doesn't apply. And that doesn't do us any good. So it's just a matter of fitting it in where it makes the most sense. But they're ready to go rather quickly if that's what we asked for.
Right, but I'm also saying that it's not like we're gonna have a report back from their work on a date certain. Like we can't say, oh, we'll get their report back or their recommendations and their executive summary by March of 2023. We can't determine that. Is that correct?
I told them that we needed to have it back before next February.
Oh, okay.
You know, when our report goes in, that's in my, okay. Or if I didn't tell them that in my original request, I told them that over the phone and they didn't think that was a problem. So.
Okay, great. Well, that's more information than I had, which is great. Maybe you sent that to us in an email. I didn't see it, so this is good to know. So the point is, we're going to have all of these reports coming back to the legislature at approximately the same time. And survivors have a voice, a seat at the table in the Governor's Advisory Council. So I would recommend the chair recognizes Senator Mirmont. I love it when people show me up.
Thank you, Mr. Chair. And I see where you're going. And because of that language that allows a bill to be reported out, I can relax some of my concerns because it could be revived quickly with that provision. So I see what you're doing.
Thank you, Senator Mirmont. Are there any other questions about including in our amendment the 7B? Any objections to 7B? And Janet, can you please put that back up on the screen just so that we are literally on the same page? So 7B2, see, I knew there was something I missed. 7B2. Any objections from any member of the committee to taking this approach to item 7 regarding the advisory council?
Can I clarify, Senator Hickman?
You may clarify.
Would you want to say that as the Adjutant General require the submission of the report by February 15th? That's part of the first annual report, and then add in here the report from OCI, just put it all together. So this could be, when you see the language, if this is what you vote for, there will be the annual reporting requirement by the Adjutant General. And then there could be unallocated language that says, for the first report due February 15th, 2023, include a couple of extra things. One of the extra things would be the report from the advisory council that's submitted to the governor. And one of the other extra things could be the OCI report. Does that sound like what you were trying to propose?
I think that's a great idea. And it doesn't necessarily mean I was trying to propose that, but my goodness, what a great idea that is. Does anyone on the committee have any objection to that great idea that just came from the sky, just like that? So that the unallocated language would be comprehensive to the reports that the Adjutant General will be giving to the VLA committee. And we will, of course, see all of this in a language review. But does anyone have any objection to that? I don't see any objections unless I'm going to allow Janet to finish writing the sentence so that we can be on the same page. The chair recognizes Senator Mirmont.
Thanks, Mr. Chair. Is this language review as she finishes this, since this is our last day? What's language review?
So language review for this bill will be done via email.
All right.
And I do believe, I shouldn't say that for a fact, because I do believe that committees do have the authority to meet up until, what is it? I have to look at the guidance. I believe it's maybe April 1st. And one of the things that we have the authority to meet about is language reviews, but not works. We can't have another work session.
Okay.
So
Well,
I will check that, but if we can't have a meeting to look at the language, because we can't have a meeting to look at the language, we will certainly get the language in our email and deliver to our seats in both chambers. Chair recognizes Senator Farron.
Just on that point, Mr. Chair, I really, this is really important stuff and touches a lot of different places. And I'm making the assumption we're going to have a vote out here shortly, is that before this bill gets, leaves the committee, that we have that chance to have that language review, because between us members here, right, with what happened with the main veterans home piece, that left the committee before we had a chance to raise some of those things, and it created some extra efforts. How about that?
Well, we did have our language review. It was just that what we thought we were changing in the language review didn't quite make it into the final bill. And so that is why we did that floor amendment. I guess, yes. The answer is yes, Senator Farron, to your question. We will absolutely be able to look at the language before this bill is reported out of committee And Darlene knows that she tends to ask me before bills are reported out if they're ready to be reported out. And in this case, on this bill, we will not report this bill out until it's ready to be reported out, which means everyone will have had a chance to look at it. I may even require that you respond and not just have it be a, oh, I didn't respond, so therefore the bill can be reported out. How does that sound, Senator Farron?
Perfect. And no, I said perfect. And yeah, just, hey, listen, that idea didn't fall out of the sky. That came from our very outstanding analyst, Janet.
I just say that because I know that, there's always that line between suggesting policy and not. So yes, we know that Janet is the best, always and forever. Amen. So
I
Janet,
did want to say for language review, I might be able to, I don't know, because I have a lot of other bills that are hitting my desk at the same time. I might be able to have like a rough language for you. I don't know if you can meet Friday. I don't remember. I have to reread the guidance as well to look at, but it would be my language. There's no way this is going to get through the revisor's office and you see that language by the end of this week. And I don't believe you can do any meetings the following week without lots and lots of begging and pleading and permission. I didn't just say that on YouTube today.
it's just the nature of where we are in the calendar. So, okay, great. If we can meet on Friday and look at this, if people are able to do that, if the guidance allows for it, then we can certainly do that too. But it will be the pre-revisor of statutes language, Janet's, Opla's, not the final language. But I'm saying on mic to everyone, we will not report the bill out until all of us have had an opportunity to say yay or nay to the final language that comes from the revisor of statutes and gets reported back to the clerk before the bill is reported out. So that's the agreement that we are making with each other at this moment. So Janet, if you could stop sharing your screen. The chair would entertain a motion. Chair recognizes Senator Miramont.
Thank you, Mr. Chair. I move that we move the amended language ought to pass. And we've talked about it plenty. I think we're clear and we'll review it as promised. So it's a motion ought to pass as amended.
Motion is ought to pass as amended on LD 2029. Is there a second?
Second.
So the motion is ought to pass as amended, and it is the committee amendment that has been on the screen for the last 5 minutes. 1, 2, 3, 4, 5, 6. I need Representative Wood, please, to turn on her camera. The motion is ought to pass as amended. It's been moved by Senator Miramont, seconded by Representative McCray. Any discussion on the motion? Committee is ready for the question. Darlene, please call the roll.
Senator Hickman,
Yay.
Senator Miramont,
Yay.
Senator Farron,
Yay.
Representative Chiazzo is absent. Representative McCray,
Yes.
Representative Riley,
Yes.
Representative Supika,
Yes.
Representative Wood,
Yes.
Representative Kinney is absent. Representative Harrington, absent. Representative Corey is absent. Representative Dollif is absent. 7 in the affirmative and 6 absent.
7 members of the committee have been voted in the affirmative, none in the negative, and 5 members absent. The motion prevails. Anything else that the committee wants to discuss? Say, Chair recognizes Senator Miramont.
My head's always in the clouds. Thank you, Senator.
I will close the work session on LD 2029. Janet has informed us that she may have a rough draft or her draft of this amendment on Friday. We will find out whether or not we can meet on Zoom to look at it, but at the very least, we will have it in our email inboxes to discuss, to make sure that it represents so far the will of this committee. I want to thank all of you for your patience and support for survivors of sexual assault in the military and in Maine generally. This has been quite a journey. I really want to thank the Adjutant General for his robust participation in this process, helping us get to a place where we could all agree on something on a subject that's difficult. I want to thank the governor and her office for their executive order, making sure that we can get this process started sooner rather than later. Anything that comes out of the office of the governor, of course, can just begin whenever it's convened and she makes her appointments. I want to thank the Attorney General and his office for helping us as well and being willing to do this independent review. In the meanwhile, I think that's extremely important. I want to thank District Attorney Megan Maloney for providing her expertise and insight today as well. And of course, Janet, you're the best. We love you to death. Darlene, thank you so much for coming in and helping us get our work done. This is our last official day of this committee. And what a note we end on. A unanimous committee report so far on quite a subject. So I will close the work session, or I think I did already. I'll do it again. Thank you all. We will see you tomorrow in session. The Joint Standing Committee on Veterans and Legal Affairs stands adjourned. Have a good evening, everyone.
Thank you. See you tomorrow.
I created packets of all the stuff that we got today. I'll bring it up to you tomorrow.
Thank you.
You don't have to print it off.